Good morning, Mr. Greaney.
Good morning, sir. The Omagh Bombing Inquiry, your inquiry, was established under Section 1 of the Inquiries Act 2005. And as everyone knows, its purpose is to investigate whether the bombing could have been prevented by UK state authorities. It is inevitable, as all core participants recognise, that in order to discharge its terms of reference, the inquiry will have to consider evidence that is sensitive on national security and possibly also other grounds. That in turn means that it's inevitable that the state core participants will in due course make applications under Section 19 of the Act, which, if successful, would have the effect of excluding the public, some core participants, including the bereaved families and survivors, and their legal representatives from some evidential hearings, namely the closed hearings. So we recognise, the inquiry legal team recognises, that the bereaved families and survivors have spent more than 25 years seeking the truth of whether the atrocity in Omagh on the 15th of August 1998 could have been prevented, and that they are suspicious or even cynical of the UK state's willingness to engage in a way that is straightforward and wholehearted with this inquiry. We acknowledge too that the idea of evidence being heard in circumstances in which the families and survivors will be excluded is one that they will find difficult to accept, to say the least. And accordingly, we regard it as entirely understandable that some, although not all, of the bereaved family and survivor core participants have suggested that special advocates should be appointed to represent their interests in any closed hearings and have made applications for that to occur. And so, of course, today and tomorrow and Wednesday, if necessary, have been set aside in order for you to hear argument upon those applications. If anyone imagined that the answer to those applications was straightforward, the next 2 days, or even 3, will disabuse them of that thought. In the thoughtful and helpful written submissions that you have received from all core participants, some argue that as a matter of law, special advocates cannot be appointed in a statutory public inquiry, and that, even if such a power exists, it should not be exercised in the circumstances of your investigation. Conversely, others argue that special advocates may be appointed in a statutory public inquiry as a matter of law, and they contend that such an appointment should be made in our circumstances so as to ensure that the interests of the bereaved families and survivors are protected. Yet others argue that a power to appoint special advocates does exist, but either contend that it should not be exercised in our circumstances or are neutral as to whether that should occur. And finally, one family group simply observes that they are content to leave matters to the inquiry legal team enclosed. We have noted, sir, that no core participant has contended that special advocates need to be appointed because of a lack of faith in the inquiry legal team. And we are grateful for and heartened by the confidence that has been expressed in us as a team and in you, sir, as a chairman. We make plain that however you rule on the applications for the appointment of special advocates, we will be driven, both in open and in closed, to establish the truth. Ahead of applications for the appointment of special advocates on the 9th of May of this year, the inquiry legal team issued a guidance note on the special advocates issue. That note explained the role of a special advocate and listed the subjects that should be covered in any application for their proposed appointment. Applications were then lodged and responses received from those who opposed appointment. Subsequently, the inquiry legal team issued a note on special advocates dated the 17th of June. That note was prepared from an independent perspective and was drafted both to assist you, sir, in your decision-making and to give core participants a framework against which to make their own oral submissions at this hearing. Both the guidance notes and the further notes invited the core participants to engage with 3 broad issues. Those issues were as follows. First, in a statutory public inquiry established under Section 1 of the Act, is there a power for a special advocate to be appointed to represent the interests of a court participant who is excluded from a closed hearing? And, if so, from where does that power derive? Second, if such a power exists, what factors are relevant to the exercise of the discretion? In the circumstances of this inquiry, how should that discretion be exercised and why? And whose interests should the special advocate or advocates be appointed to represent? And so, issue 3, if you conclude that a special advocate or special advocates should be appointed to represent one or more court participants, what are the practicalities involved in that appointment, and by whom should the appointment be made? Who should fund the appointment, and from where does the power to fund derive? And what other practicalities would be involved in the appointment? So we consider that those remain the 3 issues upon which the court participants should focus during the course of this hearing. We propose to set the scene, sir, for the argument on these issues by setting out some high-level views and by posing questions in the following order. First, because not all who are present or in any way watching will understand the role of a special advocate, we will provide an overview of what that role involves. Second, we'll address some of the legislation providing for the appointment of special advocates in different contexts. Third, we will deal with some of the case law providing for the appointment of special advocates. Fourth, we'll deal with decisions in other public inquiries on applications that were made in those processes for the appointment of special advocates. Fifth, we will address the impact, if any, of the Investigatory Powers Act 2016, the IPA. Sixthly, it will be necessary, sir, to consider the impact of the European Convention on Human Rights, in particular Article 2, which, as all know, protects the right to life. Seventh, we will pose the question, is there a power to appoint a special advocate in a public inquiry? We will not propose to answer that question, but we will identify some factors which, so it seems to us, go to that question. Eighth, we will ask, if a power exists, what are the factors that are relevant to the exercise of the discretion whether to exercise that power? Ninth, we will ask, should a special advocate or special advocates be appointed in the Omagh Bombing Inquiry? Again, we will not purport to answer that question, but will identify factors that seem to us to be relevant to it. 10th, we will consider whose interests the special advocates should be appointed to represent if they are to be appointed. And 11th, and finally, we will deal briefly with the practicalities of appointment if that stage is reached. So, sir, first of all, an overview of the role of special advocates. The Guide to the Role of Special Advocates, issued by the Special Advocate Support Office, SASO, explains that the Attorney General of England and Wales maintains a panel of special advocates in England and Wales, and of particular relevance to the Omagh Bombing Inquiry, a panel in Northern Ireland. Pausing for a moment, any appointment in Northern Ireland is made by the Advocate General of Northern Ireland, who is also the Attorney General of England and Wales, so Lord Hermer. The Treasury Solicitor has confirmed this is the position in a letter dated the 14th of July of this year, so which is at page 200 of your submissions bundle. The Treasury Solicitor has also confirmed that Lord Hermer agrees with the position of the Secretary of State for Northern Ireland on this application. The Secretary of State contends, as sir you know, that there is no power to appoint a special advocate in a statutory public inquiry. And this brings a number of issues to the surface, but in particular this. It appears to be the position that, as we'll explain further in one moment, a special advocate is appointed by a law officer. Accordingly, any appointment would not be by you, sir. So it seems to us that what you would be doing, if you agree with the applicants, is declaring the existence of a power and your wish that it be used, and then asking the law officer, here the Advocate General, to exercise that power by appointing a special advocate. So, what happens, we ask, if you conclude there is a power to appoint a special advocate and that the power ought to be exercised, but the Advocate General disagrees on both points, as appears to be his position? Procedurally, that situation seems to us, if we can put it this way, to be a messy one, and we would seek the core participants' assistance in relation to that issue during the course of this hearing. To return to the role of special advocates, a special advocate is appointed, as we've indicated, by a law officer to represent the interests of an excluded party, namely an individual who is not permitted to see closed material or be present at a closed hearing. However, a special advocate is not accountable to the excluded party. A special advocate does not take instructions in the traditional sense and has the discretion to take any decisions they consider to be in the excluded party's best interests. Once a special advocate has seen the closed material, they cannot communicate with the excluded party, save in a narrow run of circumstances. Generally, the special advocate will take part in the closed hearing, representing the interests of the excluded party, although the extent of the role of a special advocate at such a hearing differs depending on the context. So next, and secondly, we'll turn to legislation in other areas providing for the appointment of special advocates. We submit that in deciding if there is a power to appoint a special advocate in a statutory public inquiry, it is instructive to consider other statutes that specifically allow for such an appointment. Before 1997, there was no system that allowed a specially appointed advocate to consider and challenge material withheld from an applicant in legal proceedings. The development of the special advocate system was proposed in response to the decision of the ECHR in Jahal and the United Kingdom, 1997, 23 EHRR 413. In response, the UK government introduced the Special Immigration Appeals Commission Act 1997. This act established the Special Immigration Appeals Commission, SIAC, an independent judicial tribunal to hear immigration appeals against Home Office decisions. Section 6 of that Act made provisions for a special advocate to represent an appellant in cases where immigration decisions by the Home Secretary involved security-sensitive evidence that could not be disclosed. The Special Immigration Appeals Commission Procedure Rules 2003, and specifically Part 7, govern representation at SIAC. Rule 34 permits a law officer to appoint a special advocate. Rule 35 outlines the special advocate's functions, allowing them to make submissions, to present evidence, and cross-examine witnesses in hearings from which the appellant and their representatives are excluded. Rule 36 details communication protocols for special advocates, stating that after the service of the closed material, quotes, the special advocate must not communicate with any person about any matter connected with the proceedings except in accordance with paragraph 3 or a direction of the Commission pursuant to a request under paragraph 4. So paragraph 3 deals, as you know, with persons other than the appellant or his representative. And paragraph 4 deals with a request for directions from the Commission for authority to communicate with the appellant or his representative or another person. And so, sir, in simple terms, as we've indicated, once the special advocate is exposed to the closed material, the circumstances in which he or she may take instructions are narrow indeed. So Rule 36 further reinforces the open-closed divide and the inability, with limited exceptions, of the special advocate to communicate with those whose interests they represent. As has been observed in other processes, this may mean that a special advocate would be of less utility to excluded core participants than the inquiry legal team, who would be able to continue to communicate with excluded core participants, even though they must, of course, respect the terms of any restriction order. Since 1997, the government has introduced a broad spectrum of statutes that include provisions for appointing a special advocate or a similar express mechanism for representing excluded parties, or it has amended statutes to create that same state of affairs. In our written submissions, we have provided a non-exhaustive list of such statutes, ranging from the Planning Hazardous Substances Act of 1990 to the Justice and Security Act 2013. So we observe that, in general, the legislation seems to follow a common structure. It allows for rules to be made under the governing statute, and these rules typically, 1, permit hearings to proceed in the absence of a party because of the need to consider sensitive material, and 2, enable that absent party's interest to be represented in another way. Generally, the legislation anticipates that the rules will provide for a special advocate, and where a special advocate is provided for, their appointment, functions, duties, and communication protocols are usually expressly set out. As is obvious, the Inquiries Act 2005 and the rules made under Section 41 of the Act do not conform to that common structure. While Section 19 provides for the hearing of evidence in restricted circumstances, such as to safeguard national security, it makes no express provision for, nor identifies any mechanism by which the interests of an excluded core participant may be represented. The general thrust of the arguments of those core participants who seek or support the appointment of a special advocate is that the avenue for doing so is provided by Section 17 of the Act. Section 17, of course, provides as follows, quotes, 1, subject to any provision of this Act or of rules under Section 41, the procedure and conduct of an inquiry are to be such as the chairman of the inquiry may direct. And Section 17 goes on to provide, 3, in making any decision as to the procedure or conduct of an inquiry, the chairman must act with fairness and with regard also to the need to avoid any unnecessary cost, whether to public funds or to witnesses or others. End quotes. The Police Ombudsman of Northern Ireland, Pony, has suggested in written submissions that Section 18 of the Act may provide an alternative route to the appointment of a special advocate. As with all of the submissions received, Pony's submissions are welcome. But the inquiry legal team considers this particular submission to be wrong. Section 18, it currently seems to the inquiry legal team, emphasises the importance of public access to the proceedings of the inquiry, although subject to any restrictions imposed by a restriction order or restriction notice, but says nothing or nothing of significance about the existence or otherwise of the power to appoint a special advocate. The position of Pony will, as we explained in our note of June, need to be tested, we suggest, during the course of this hearing. So overall, the legislation reviewed in our note is indicative of Parliament's consistent recognition of national security issues. That recognition has frequently led to the inclusion of provisions that exclude disclosure and evidence for national security reasons, alongside express arrangements for representing excluded parties' interests through the special advocate procedure or similar mechanisms. We observe again that the Inquiries Act lacks any such express provisions, and core participants should, we suggest, address at this hearing whether that absence suggests that Section 17 was not intended by Parliament to permit the appointment of a special advocate, And so we regard that as an issue of considerable importance upon which we know you will welcome submissions. Thirdly, we turn to some of the case law providing for the appointment of special advocates. There is no statutory provision allowing for the appointment of special advocates in criminal proceedings. However, the courts have inferred that power since at least 2004. In the Crown and H and others, 2004 UKHL 3, Lord Bingham explained how public interest immunity, PII, applications should work in criminal trials. At paragraph 36, Lord Bingham explained the sequential questions which a judge had to determine and concluded that, quotes, in appropriate cases, the appointment of special counsel may be a necessary step to ensure that the contentions of the prosecution are tested and the interests of the defendant protected. At paragraph 22, the committee outlined the various ethical and practical difficulties involved in appointing a special advocate, stating that, quotes, cases will arise in which the appointment of an approved advocate as special counsel is necessary in the interests of justice to secure protection of a criminal defendant's right to a fair trial. Such an appointment, the committee said, will always be exceptional, never automatic, a course of last and never first resort. And the committee went on to observe it should not be ordered, namely the appointment of a special advocate, unless and until the trial judge is satisfied that no other course will adequately meet the overriding requirement of fairness to the defendant. The courts have also been willing to sanction the use of special advocates in other types of proceedings, even without specific statutory authority. And we will draw attention, as we have done in writing, to a number of examples. The Secretary of State for the Home Department, Anne Raymond, 2003 Weekly Law Reports 1240, was an appeal in respect of a decision of SIAC. And it was decided that while there was no statutory provision for the appointment of a special advocate on such an appeal, such an appointment was nonetheless permissible. In the Crown and Shaler, 2002 UKHL 11, the House of Lords endorsed the approach adopted by the Court of Appeal in Raymond and regarded it as capable of being followed in proceedings for judicial review by a former member of the Security Service of a refusal of permission to publish. The Crown, Roberts and the Parole Board, 2005 UKHL 45, is a case relied upon by the bereaved families and survivors, or at least some of them. At the time of that decision, there was no express statutory basis for the instruction of a special advocate in proceedings before the Parole Board. However, the House of Lords concluded that such a power nonetheless existed. So we suggest it will be important to analyse this case in the course of this hearing. It is suggested in some of the submissions that Roberts obviously grants the power to appoint a special advocate in a statutory public inquiry. The inquiry legal team is currently unclear why that is obvious. Those who argue that there is a power to appoint a special advocate in a statutory public inquiry rely upon Section 17 and Pony, as we've said, on Section 18. If the reality is that Parliament did not intend in Section 17 or Section 18 to empower the appointment of a special advocate in a statutory public inquiry, how, we ask, could the common law intervene? And we submit that the core participants will need to address that issue in their submissions. Malik and Manchester Crown Court, 2008 EWHC 1362 admin, concerned proceedings on an application for a production order under Schedule 5 of the Terrorism Act 2000. A power to appoint a special advocate existed, found the court, but the judge at first instance had been correct not to request such an appointment. Murungaru and the Secretary of State for the Home Department, 2008 EWCA Civ 1015, involved judicial review proceedings in respect of the revocation of a visa. It was found that a power to appoint a special advocate existed, but the judge's decision to request such an appointment was found wrong on the facts. And so the final example of a case in which the use of a special advocate has been sanctioned, notwithstanding the absence of a statutory power, is AHK and the Secretary of State for the Home Department, 2009 EWCA Civ 287, which was a case concerning judicial review proceedings in respect of a refusal of an application for British citizenship. The effect of the ruling in that case was that the appointment of a special advocate was permissible in certain situations, even without statutory authority. So, by way of overview of the case law, we submit that a key element in each of the cases we have just referred to, and in the cases overall, was the court's consideration of its power to appoint a special advocate when no other legal basis existed. However, we, on this application, are concerned with a statutory framework. As we've explained, within the context of a public inquiry, it is suggested by some court participants that Section 17 provides the necessary power for such an appointment. At the hearing, it will be necessary for this suggestion to be examined in detail and for all to engage with this question. If you were, sir, contrary to the suggestion made, to find that Section 17 does not provide a power to appoint a special advocate in statutory public inquiry proceedings, on what basis is it suggested that an inherent power arises under the common law? And again, sir, that we suggest is an important issue for all to grapple with during the course of this hearing. Fourthly, so topic 4. Fourthly, in deciding whether there is a power to appoint a special advocate in a public inquiry, it may, we recognise, be of assistance to consider the approach of other statutory public inquiries. Consideration has been given to the appointment of special advocates in at least 3 other recent public inquiries, although in the results no special advocate was appointed in any of those proceedings. So what are those 3 processes? First, the Litvinenko inquiry. An application was made by Marina Litvinenko and Anatoly Litvinenko for the appointment of a special advocate. In his decision dated the 9th of October 2014, the chairman of that inquiry, Sir Robert Owen, held as follows, quotes, 5, I have formed, said the chairman, the provisional view that the power to appoint a special advocate is implicit in the broad power to determine the procedure to be adopted in an inquiry and in the express duty to act fairly. He went on to say, I do not consider that it's possible to rule out the possibility that there might be circumstances in which the appointment of a special advocate would be necessary to enable the chairman of an inquiry properly to discharge his functions. But I recognise that such circumstances would be wholly exceptional, bearing in mind in particular the inquisitorial nature of an inquiry constituted under the Act. And then in paragraph 9, Sir Robert went on to say, bearing in mind in particular the role to be played by counsel to the inquiry under my direction, I do not consider the appointment of a special advocate to act on behalf of ML and AL to be necessary for the proper discharge of my function. Thus, on the premise that I have power to appoint a special advocate, I am not persuaded that I should do so. It follows that this application is refused. So the chairman there finding the existence of a power but declining to exercise it. In the Manchester Arena inquiry, an application was made by some of the bereaved families, although not all, for the appointment of a special advocate. In his decision dated the 7th of October 2021, The chairman, Sir John Saunders, held the following, and again we quote, "In this case, I am required to comply with the requirements of Article 2 of the ECHR, and while it may be difficult to think of examples, I am not prepared to say, as a matter of law, that there is no power to appoint special advocates to an inquiry. In my judgment, there is such a power, and my ruling in that regard accords with the ruling by Sir Robert Owen in the Litvinenko inquiry." End quotes. Despite finding that there was a power to appoint a special advocate, the chairman concluded that it was not necessary or desirable to appoint a special advocate in the Manchester Arena inquiry. The third process in which this issue was considered was the independent inquiry relating to Afghanistan. In that inquiry, an application was made by the Afghan bereaved families for the appointment of a special advocate. In a decision dated the 21st of August 2023, the chairman, Lord Justice Haddon Cave, did not express a final view on whether there was a power to appoint special advocates, having concluded that, quotes, "In my view, it is neither necessary nor appropriate for special advocates to be appointed in this inquiry for the following reasons. One, the inquiry involves an independent and impartial investigation by a specially appointed chair. Its process is inquisitorial and is aimed at getting to the truth and not adversarial. Two, I have complete confidence that counsel to the inquiry will test the evidence enclosed with the same diligence and independence as they will in the open hearings. Further, my approach to the closed hearings will be just as rigorous as in open. Three, the appointment of special advocates would duplicate the existing role and functions of counsel to the inquiry, and moreover would involve unnecessary complication and cost. Four, the appointment and involvement of special advocates would also cause significant delay in circumstances where it is important that the inquiry proceeds at pace. Five, the extent to which special advocates would be able to communicate with the Afghan families' recognised legal representative, having already had access to the sensitive material in the context of the judicial review proceedings, is limited. In any event, any proposed lines of focus or inquiry could still be communicated to counsel to the inquiry to the same end. Six, given the substantial disclosure that has already been made in open and will in due course be made, other core participants will still be able to meaningfully participate in the inquiry. End quotes. So the inquiry legal team considers that it will be helpful, indeed necessary, during this hearing for core participants to engage with the extent to which these early decisions assist you to decide A, whether a power to appoint a special advocate exists, and B, if it does, whether that power ought to be exercised in the circumstances of the Omagh Bombing Inquiry. And so just pausing for one moment, you will recall that we asked core participants to identify any other public inquiries in which the existence of a power to appoint special advocates had been considered, and so no core participant has identified any inquiries save for the three that we have just dealt with. So fifthly, we turn to the impact, if any, of the Investigatory Powers Act 2016, the IPA. In deciding if there is a power to appoint a special advocate in a statutory public inquiry, it may, we suggest, be useful to consider the interplay of other legislation, in particular the IPA. Pausing for one moment, for the avoidance of any doubt, what we're about to say is not intended to confirm or deny the existence of any intercepted communications or related conduct in relation to the work of the Omagh Bombing Inquiry. Instead, our purpose is to examine the practical implications of appointing a special advocate should consideration of any such intercepted communication or related conduct become necessary in the course of your work. Section 56(1) of the IPA prohibits the adducing of evidence, the asking of questions, the making of assertions, the making of disclosure, or the doing of any other thing which discloses the content of an intercepted communication or any secondary data obtained from a communication, if that disclosure may imply that it has come from interception-related conduct, or that tends to suggest that interception-related conduct has or may have occurred or may be going to occur. The Section 56 prohibition applies to proceedings of a statutory public inquiry. Paragraphs 22 and 23 of Schedule 3 to the IPA provide the exceptions to the Section 56 prohibition as they apply to statutory public inquiries. The Section 56 prohibition is disapplied if, quotes, in the course of the inquiry, the panel has ordered the disclosure to be made to the panel alone, or, as the case may be, to the panel and any person appointed as legal advisor to the inquiry. Legal advisor is defined as a person appointed as solicitor or counsel to the inquiry, terms which have a particular meaning under the Act and the rules. An ordered disclosure of the sort anticipated by those paragraphs may only occur if the chairman considers that the exceptional circumstances of the case make the disclosure essential to enable the inquiry to fulfil its terms of reference. That is paragraph 22(2). So, accordingly, while ordered disclosures can be made to the solicitor of the inquiry and counsel to the inquiry, it appears to be the case that there is no power for such disclosures to be made to a special advocate, if appointed. Consequently, if a special advocate were to be appointed in your inquiry, and if, sir, you had to consider material covered by Section 56(1), it seems to be the position that no ordered disclosure could be made to that special advocate, which would plainly, we suggest, reduce their utility if the closed material included Section 56 material. But, sir, whether that analysis that we have just engaged in is correct will, we recognise, require consideration during this hearing, as will its consequences if the analysis is correct. By paragraph 23 of Schedule 3, the Section 56 prohibition is also disapplied in relation to what are termed restricted proceedings, only insofar as those proceedings are considering ordered disclosures under paragraph 22. Proceedings are restricted proceedings if they operate under a restriction order or restriction notice which prohibits the attendance at those proceedings of any person who does not fall into one of 5 categories. Those 5 categories of person are 1, the chairman of the inquiry; 2, counsel to the inquiry and the solicitor to the inquiry; 3, a person who is a, quotes, relevant party to proceedings; 4, a person representing a relevant party for the purpose of the restricted proceedings; and 5, quotes, a person performing functions necessary for the proper functioning of the proceedings. It's obviously important to understand who may be a relevant party. A person may be a relevant party in one of 4 ways set out in paragraph 23(4) of Schedule 3. 1, they are the person who has made the ordered disclosure. 2, they are giving evidence to the inquiry in circumstances where, but for the paragraph 23(1) disapplication, the Section 56 prohibition would be breached. 3, they are a person who has engaged in the interception-related conduct to which the ordered disclosure relates. And 4, they are any other person to whom the subject matter of the disclosure or evidence has been lawfully disclosed in accordance with Section 58 of the IPA. So it seems to the inquiry legal team to be striking that although special advocates are expressly referenced within paragraphs of Schedule 3 that deal with proceedings other than statutory public inquiries, paragraph 23 makes no mention at all of disclosure to a special advocate, nor provides any authority for a special advocate to be present in a closed hearing considering ordered disclosure. Notably, all other legal representatives permitted to be present are expressly identified and are not subsumed as a person performing functions necessary for the proper functioning of the proceedings. And we suggest that this latter provision more appropriately refers to administrative staff essential for the inquiry's operation and is not apt to describe or include a special advocate. But again, sir, we recognise that the suggestion that we have just made will require careful analysis at this hearing, as is apparent from the submissions received from others, demonstrate it to be controversial. If, sir, ultimately you conclude that our analysis is correct, it appears to be the case that although the IPA allows for the disclosure and consideration of intercept material and interception-related conduct at a closed hearing in statutory inquiry proceedings, there is no provision for a special advocate to receive this material or attend any closed hearings where it is considered. This limitation, sir, if you agree it exists, on disclosure to a special advocate and/or attendance could be seen as a practical barrier to their effective participation in an inquiry where Section 56(1) material is considered. Moreover, if this interpretation is in your assessment, sir, correct, Parliament's failure to amend the Inquiries Act or the IPA to address this situation might suggest there is no parliamentary intention for special advocates to be involved in inquiry proceedings. And in turn, that may be because the inquiry legal team can already fulfil many of their potential functions. So again, this issue will require close analysis during the course of our hearing. So finally, before we move on to the impact of the ECHR, connectedly, some of the bereaved family and survivor core participants argue that the special advocates who were instructed in the judicial review proceedings that triggered this inquiry should be instructed in this inquiry given their existing knowledge. And that submission is understood as a matter of logic. However, we pose this question. What if the special advocates sought Section 56 material in the course of the judicial review proceedings, but could not permissibly see it in the closed hearings of this inquiry? How, we ask, would that work? Sixthly, as we indicated, the impact of the European Convention on Human Rights. The Human Rights Act 1998, more particularly Section 6(1), provides that it is unlawful for a public authority to act in a way which is incompatible with a convention right. Section 6, subsection 3b, defines a public authority as including any person certain of whose functions are functions of a public nature. So we accept as a matter of law that the chairman of a statutory public inquiry, such as you, sir, when acting as such, is a public authority as defined by the Act of 1998. And if authority for that self-evident proposition were to be required, it is provided by the Crown EA and the chairman of the Manchester Arena Inquiry, 2020 EWHC 2053 admin. Section 3 of the Act of 1998 provides that, so far as it is possible to do so, primary legislation and subordinate legislation must be read and given effect in a way which is compatible with the Convention rights. As everyone knows, Article 2 of the ECHR protects the fundamental right to life. In Alscaney, 2011, ECHR 1093, the European Court of Human Rights held, and we quote, "The obligation to protect the right to life under this provision, read in conjunction with the state's general duty under Article 1 of the Convention to secure to everyone within their jurisdiction the rights and freedoms defined in the Convention requires by implication that there should be, and then we emphasise these words, some form of effective official investigation when individuals, have been killed as a result of the use of force by, inter alia, agents of the state. The essential purpose of such an investigation is to secure the effective implementation of the domestic laws safeguarding the right to life, and in those cases involving state agents or bodies, to ensure their accountability for deaths occurring under their responsibility." End quotes. It appears to the inquiry legal team, although subject of course to argument at this hearing, that an effective investigation compliant with Article 2 does not necessitate full public access or complete access for core participants to all aspects of the inquiry proceedings. This principle was explicitly acknowledged in both the Crown and Armin and the Secretary of State for the Home Department, 2003 UKHL 51, see paragraph 28 and paragraph 29, and Ramachai in the Netherlands, 2008 46 EHRR 43, see paragraph 353. It is also apparent, it currently seems to the inquiry legal team, from the very existence of the restriction order procedure in section 19 of the Act. So, the inquiry legal team observes that jurisprudence does not appear to support the contention that special advocates are required to fulfil the Article 2 obligation to conduct an effective investigation. So if further support for this contention is required, the inquiry legal team notes that numerous previous public inquiries, including those that incorporated closed hearings, have been conducted successfully in compliance with Article 2 in the absence of special advocates. But once more, the significance, if any, of that requires close scrutiny at this hearing. So we turn seventhly to the question of whether there is a power to appoint a special advocate in your process. Without arguing for an answer one way or the other, we observe the following. First, Section 17 of the Inquiries Act gives a chairman a broad power to determine the procedures and conduct permissible during an inquiry. This power is subject to the requirement that the chairman acts with fairness and with regard to the need to avoid any unnecessary cost, whether to public funds or to witnesses or others. In two previous statutory public inquiries, chairmen have been prepared to proceed upon the view that Section 17 is wide enough to allow for the appointment of special advocates, though no such appointment was requested in the result. So, in our assessment, there is no doubt that these decisions of senior and experienced judges sitting as chairman require close consideration during this hearing. While you are entitled to form your own view and are certainly not bound by the decisions in the Litvinenko inquiry and or in the Manchester Arena inquiry, we suggest that in practice you will need to identify cogent reasons if you are to depart from their reasoning. Second, while the Inquiries Act permits closed hearings, whether pursuant to a restriction order or restriction notice, it makes no express provision for the appointment of a special advocate. Parliament did not include such a provision, despite typically doing so in statutes where sensitive or national security sensitive evidence is expected to be handled in a closed hearing, often through a special advocate or similar mechanism for representing excluded parties. The inquiry legal team observes that the Inquiries Act lacks any such express provisions, and this absence might suggest that Section 17, as we've submitted already, was not intended by Parliament to permit the appointment of a special advocate. Third, many of the functions typically performed by a special advocate are already carried out by the inquiry legal team. The inquiry legal team operates independently of all core participants, and your team, sir, comprises several experienced security vetted solicitors and 7 experienced security vetted counsel, at least some of whom would be involved in any closed hearings. The inquiry legal team suggests that this overlap in functions may explain why there is no provision for special advocates in the Inquiries Act, as the inquiry legal team effectively performs many, if not all, of their core duties, albeit from an independent and inquisitorial standpoint. Furthermore, the use of the inquiry legal team ensures that the closed material is considered not only by counsel, as would be the case when a special advocate is appointed, but also by solicitors who would not be available to a special advocate, or at least not in the same all-in way. So that, we suggest, is an important issue for consideration at this hearing. Fourth, the inquiry legal team observes that although the Inquiries Act and the IPA allow for the disclosure and consideration of intercept material and interception-related conduct at a closed hearing, there is no apparent provision for a special advocate to receive disclosure of this material or to attend any closed hearing where it is considered. And as we have observed already, this limitation, if that is what it is, on disclosure to a special advocate and attendance could be seen as a practical barrier to their effective participation in any inquiry if material caught by Section 56(1) requires consideration. So if this interpretation is correct, Parliament's failure to amend the Inquiries Act or the IPA to address this situation might suggest there is no parliamentary intention for special advocates to be involved in inquiry proceedings, perhaps because the inquiry legal team can already fulfil many of their potential functions. Fifth, while Article 2 of the Convention requires that public inquiries are effective and involve core participants to the extent necessary to safeguard their interests, it does not require the appointment of a special advocate where the inquiry will hold closed hearings. It may be argued that the inquiry's inquisitorial nature ensures effective participation through open hearings, with derogation from open access limited to the minimum extent possible, the diligent work of counsel to the inquiry and the solicitor to the inquiry, and, sir, your independence as chairman. Sixth, we observe that the process for taking evidence at the inquiry hearings is under Rule 10 of the Inquiry Rules of 2006. By Rules 2 and 6, and subject to Rule 7, where a core participant has appointed a qualified lawyer to act on that person's behalf, the chairman must designate that lawyer as that person's recognised legal representative, RLR, in respect of the proceedings of the inquiry. It is only the RLR that is able to ask questions. A special advocate who is not appointed by the core participant but instead by the law officer, on the face of it, is not capable of being an RLR within the meaning of the rules. The absence of express provisions allowing a special advocate to ask questions might suggest there is no parliamentary intention for special advocates to be involved in inquiry proceedings, although once again this interpretation of the rules will, we acknowledge, require close examination at the hearing. And so that is all we propose to say at the moment about that seventh topic. Does a power exist? Eighthly, if a power exists, what factors are relevant to the exercise of the discretion whether to exercise it? So if you determine that Section 17 does incorporate a power to appoint a special advocate, then the exercise of that power is, subject to the requirement that you act with fairness and with regard to the need to avoid any unnecessary cost, a matter for your discretion. In the Crown and H 2004 UKHL 3, a case to which we've already referred, At paragraph 22, the committee outlined the various ethical and practical difficulties involved in appointing a special advocate, and they stated this, quotes, and at the risk of repetition, cases will arise in which the appointment of an approved advocate as special counsel is necessary in the interests of justice to secure protection of a criminal defendant's right to a fair trial. Such an appointment, said the committee, will always be exceptional, never automatic, a course of last and never first resort. And the court went on to say it should not be ordered unless and until the trial judge is satisfied that no other course will adequately meet the overriding requirement of fairness to the defendant. End quotes. In AHK and the Secretary of State for the Home Department, 2009 EWCA Civ 287, at paragraph 35, the court set out its view as to the correct approach in cases of, as it was put, this kind generally, and returned to consider the correct explanation of the test for the appointment of a special advocate. The court did so in the following terms, quotes, as we indicated above, the test suggested by Miss Giovanetti, she was appearing as counsel for the Secretary of State, was that, and we emphasise this passage, a special advocate should only be appointed if it is necessary to do so. We do not think that such an approach is markedly different from that suggested in the cases. In any event, it seems to us that it will be necessary to appoint a special advocate where it would be just to do so. Given the very few cases in which these problems arise, viz. Some 138 in 4 years, in circumstances in which about 100,000 applications for citizenship succeed each year, these are exceptional cases. In our view, the test is best stated as being that a special advocate should be appointed where it is just to do so, having regard to the requirement that the proceedings must be fair to the claimant and to the Secretary of State. End quotes. The inquiry legal team observes that AHK appears to replace a test of strict exceptionality with one of necessity, although that might mean something very similar. As a guide to finding when the test of necessity will be met, the court suggests considering whether it is just to appoint a special advocate, having regard to the requirement of fairness. We suggest, sir, that in deciding whether to appoint a special advocate, if you conclude that you have power to do so, you should consider whether it's necessary for a special advocate to be appointed for the Omagh Bombing Inquiry to achieve its purpose, taking account of the requirement that you act with fairness and with regard to the need to avoid any unnecessary cost, whether to public funds or to witnesses or others. So, ninthly, we turn to the question of whether special advocates should be appointed in your inquiry if you conclude that there is power for an appointment to be made by the law officer. So we turn then to the question of whether special advocates should be instructed. Without arguing for any particular outcome, so we observe the following. First, this inquiry involves an independent and impartial investigation by a specially appointed chairman. Its process is inquisitorial and is aimed at getting at the truth. Its process is not adversarial. So the inquisitorial nature of the proceedings, with neither the core participants nor the inquiry legal team having a case, is, it seems to the inquiry legal team, important, or at least potentially so. Second, but connectedly, the use of a special advocate would arguably not be consistent with the inquisitorial nature of a statutory public inquiry. One purpose of the appointment of counsel to the inquiry is to provide for the advocacy function in an inquisitorial context. Counsel to the inquiry will be able to probe the evidence in closed hearings, supported by the solicitor of the inquiry, and so your team contains members with particular experience of doing so. We do acknowledge that a special advocate would offer some advantages, as counsel to the inquiry must act in accordance with the inquisitorial nature of the proceedings, whereas in contrast a special advocate would specifically investigate the evidence from the point of view of the core participant whose interests they represent. The core participant in question, we recognise, may feel greater confidence that their interests are being properly considered in the evidential investigation as a result. Although, sir, in this regard, it's noteworthy that some of the core participants have expressed confidence in the approach adopted by the inquiry legal team to date. Nonetheless, this second factor will be an important issue for your consideration at this hearing, we suggest. Third, a special advocate may take instructions from their client before seeing the closed documents in a case, and may not communicate further with their client after seeing the closed documents, save in a very narrow run of circumstances. Unlike a special advocate, vetted members of the inquiry legal team who have already seen the closed documents may continue to communicate with the core participants and their lawyers. The involvement of the inquiry legal team, comprised, of course, of both counsel and solicitors, may therefore be of more value to the core participants than the involvement of a special advocate would be, because continued dialogue can guide the inquiry legal team in issues that are of particular concern to core participants. Fourth, as we have observed already, there may be a duplication of function between the inquiry legal team and special advocates appointed for core participants. And this arguably engages the obligation that you have, sir, under Section 17(3) of the Act of 2005, to have regard to the need to avoid unnecessary costs when making decisions as to the procedure or conduct of the inquiry. However, we acknowledge that this duplication of function and resultant increase in costs would arguably be justified if you determined, sir, that it is necessary to appoint special advocates for the inquiry to achieve its purpose, taking account of the requirement that you act with fairness. Fifth, the inquiry legal team observes that the use of a special advocate in this inquiry would be novel, indeed unique. Special advocates have not been utilised in any previous statutory inquiry, even though several past statutory inquiries have also dealt with sensitive material and held closed hearings. In the Litvinenko inquiry, the Manchester Arena inquiry, and the independent inquiry relating to Afghanistan, no request for the appointment of a special advocate was made by the chair following applications that he should do so, and in the Dawn Sturgis inquiry, an inquiry which scrutinised claims of the involvement of a hostile state in a death, no application was made for the appointment of a special advocate by any core participant. While the lack of a precedent alone is not a determining factor, it may be relevant that previous statutory inquiries have shown, sir, that effective and comprehensive investigations, including those with closed hearings, can be conducted without the appointment of special advocates. Sir, as a result, we ask the core participants to address this question during their submissions. Is there any sound reason to think that the Omagh Bombing Inquiry would be any different? Sixth, if the application is granted and special advocates following, sir, a request by you are appointed, there seems to us to be an obvious risk of delay to your investigation. The volume of closed material is likely to be significant. It will inevitably add some delay if the material has to be read by special advocates, particularly if more than one, and by the inquiry legal team. Further, if the analysis in relation to the application and operation of the IPA is correct, and such material were identified in the Omagh Bombing Inquiry, then the procedural position would be complex and would likely contribute to further delay in closed proceedings. The availability of special advocates and premises to accommodate them in Northern Ireland may be an additional complication, and these practical issues require consideration, we suggest, sir, at this hearing. Seventh, in Ray Gallagher's application for leave to apply for judicial review, 2021 NIQB 85, as we've said already, the proceedings which resulted in this inquiry. In the judgment of Mr. Justice Horner in that case, the court stated the following, quotes, "The applicant submits with good reason that it is essential to ensure that public concern will be addressed by any inquiry and that this will be so sufficiently robust to ensure that there is public confidence in the outcome. The inquiry chairman is given wide powers to act fairly and impartially. There is also the ability to hold closed hearings and to appoint special advocates, which may be particularly apposite here, given that much of the evidence will be in closed." And the judge then cited the decision of Sir Robert Owen in Litvinenko. So this commentary by Mr. Justice Horner, as he was, on special advocates appears to have been obiter, given that the High Court did not order the establishment of a public inquiry. Nonetheless, the fact that the High Court here in Belfast appears to have regarded the potential appointment of special advocates in the Omagh Bombing Inquiry as a relevant factor is arguably relevant to the exercise of your discretion, if indeed, sir, you conclude that you have one. And eighth, sir, and finally, on the factors that would be relevant to the exercise of that discretion, if it exists. Given the substantial disclosure that has already been made in open and will in due course be made, other core participants will be able to participate meaningfully in the inquiry through the Rule 10 process in open and continued communication with the inquiry legal team. So, 10th, whose interests should the special advocate or advocates be appointed to represent? And we have little to say about this, having addressed the issue in writing. If you do decide, sir, that you have a power to request the appointment of special advocates, if you decide to make such a request and if special advocates are appointed by the Advocate General, it should be noted that special advocates have been requested by the 5 teams of the bereaved and survivor corps participants represented by John McBurney solicitors, Fox Law solicitors, Campbell and Hohey solicitors, Logan and Corrie solicitors and Roach McBride solicitors. Differing views have been expressed as to how many special advocates would be necessary. While some corps participants suggest each bereaved and survivor group requires its own special advocate due to unique interests, you could decide, it seems to us, that one special advocate team would suffice for all bereaved and survivor corps participants. In practice, of course, special advocates would only consult with the open corps participants before receiving closed material. And this means that the need to take nuanced instructions repeatedly from each corps participant group would be less pressing for special advocates than it would be for an open, recognised legal representative. And finally, sir, our topic 11, the practicalities of appointment. In our written submissions, we identified a series of practical issues relating to the appointment of special advocates, including the funding arrangements. And so we don't propose to go into those orally. Safe to note that statutory provisions for other proceedings involving special advocates are strictly prescribed, outlining procedures for special advocates taking instructions, for their engagement in the proceedings, for their ability to make submissions, ask questions, and so on. As so, there is no statutory regime for special advocates in inquiry, at least not one that descends into the detail of how they are to be appointed and how they are to operate. If you decided you had a power to make a request, if you decided to make a request and if there were an appointment by the law officer, so you would need to develop your own protocols for the management of special advocate engagement. So that is all we propose to say at the outset of and in opening this hearing. What we propose is that we should take a short break at this stage, following which we will call upon Mr. Southey, King's Counsel, to address you on behalf of those that he represents.
Yes, thank you very much.
So shall we aim to return at about 11:20?
A break at this stage is in order to accommodate the needs of the stenographer.
It is.
So it depends how long she would need. I note that she's been valiantly typing for over an hour. 10 minutes might not be very long.
So, may I consult with the stenographer and we'll take a break for as long as she needs?
Yes, thank you. Good morning, Mr. Southey.
Good morning, sir.
Mr. Southey, before we start, I wondered if I could ask you just to clarify one matter for me. And it really arises out of the point that Mr. Greaney was making, to the effect that the chairman of a public inquiry would not have the power himself to appoint a special advocate, and that that power would reside with the relevant law officer. Is that something you accept or not?
Well, in perhaps sort of a typical lawyer's answer, yes and no. What I mean by that is that I accept that ultimately the actual appointment is made by a law officer, by the Advocate General for Northern Ireland. The Advocate General retains the list of security cleared special advocates, and it is for the Advocate General to decide, for example, whether someone is disqualified because of tainting. However, we would argue that if you were to conclude that for reasons consistent with your obligations under the Inquiries Act, that a special advocate should be appointed, or it would then be unlawful for there to be a refusal to appoint a special advocate. And we say that for two reasons, essentially. Firstly, to the extent that Article 2 clearly does apply, but because Article 2 applies, it is for you, sir, to determine what steps should be taken in your inquiry, and if authority is needed for that, it is the judgment of Lord Roger in JL, which you can find in the Authorities Bundle, tab 24, page 506, para 76, where he says once an Article 2 inquiry is established, it is for the investigator to decide how to conduct their investigation. And that's obviously reflected in Section 17.
But all I was really wondering is whether you accept that what I should do if I agree with your submissions is to make a request rather than to actually make an appointment. And then if for whatever reason the law officer declined to follow that request, well, that would be something you would take up with him.
Yes, that's the procedure we would accept would need to be followed. But that's, as I say, is not uncommon. That's effectively what happens. It's certainly in my experience in other contexts where closed procedure, in something like SIAC, for example, it is ultimately left to the law officer to make the appointment.
Yes, well that's helpful. Thank you. So you have your written submissions,
yep.
And I imagine you're going to take me through those.
Yes, I'm going to not necessarily repeat everything, but seek to develop them in some detail. Can I also just start, though, by thanking the inquiry for the time it's putting aside for this issue at this early stage, relatively early stage. Obviously, the core participants that I represent have, from the very early days of this inquiry, been arguing for the appointment of a special advocate. And in simple terms, the reason for this is that they obviously have, as is probably clear, a degree of scepticism about the state's position in relation to this inquiry. There has been considerable delay in getting to this stage, and also there is a history, they would argue, of the state not necessarily providing full open, or being fully open, essentially, about what's happened in the past. And because of that, they are of the opinion that it is particularly important that any closed procedure involves the state being fully tested, and it's important also that they have confidence in the outcome of any closed procedure. And in that context, they would argue that the judicial review provides a good model, and in the context of the judicial review, they certainly would argue that it's their impression And in one sense, it can be no more than an impression, but it's their impression that the special advocates played an important role. And that role the special advocates have played in the past in the judicial review is part of the reason why, from their point of view, it is important that special advocates continue to be involved in the process.
I follow all of that very easily, but right at the beginning, you raised the question of, or the issue, which others have raised also, of scepticism in relation to the state.
Yeah.
It's very important to emphasise that the distinction between the state and this inquiry. I'm not the state for the purposes of this inquiry.
I'm not suggesting, I wasn't intending to suggest, and I'm not suggesting that you sir, are the state. The reason I make that point is because, and I'll come on to this, we recognise that the important role that both you and Counsel to the Inquiry play in testing the evidence. But ultimately, there are limitations, particularly in relation to the role of Counsel to the Inquiry, and I'll come on to those. And that's where a special advocate in our submission potentially plays an important role in further testing the state in the closed procedure. And it's not that the inquiry is the state, just to repeat really in some senses, it is that the special advocate, it's that rather the closed procedure will be part of how the state is tested, and the special advocate has a role to play in doing that. That's really the point I was trying to make. Can I then turn to the issue of the power to appoint the special advocate and whether or not you have, sir, a power? There are a couple of matters that are not in dispute. Firstly, nobody argues that there's an express power to appoint a special advocate. We say, however, that doesn't take the inquiry necessarily very much further in determining the issues that arise as a matter of law, because there's nothing that prevents expressly the appointment of a special advocate. It would have been easy to expressly provide in the rules that their special advocate couldn't be appointed. And it's clear that there are contexts in which a power to appoint a special advocate has been identified by courts, despite the absence of anything expressly in legislation enabling that. And that raises the question of what it is, what principles have the courts applied and identified when deciding that there is a power to justify to appoint a special advocate. Now, I'm going to address that case law, and I will suggest that there are two matters that lead to the conclusion that there's a power to appoint a special advocate. But before doing that, I probably need to address the statutory framework. Statutory framework obviously is found in the 2005 Act. I should say, before turning to it, submissions have been made by PS&I in particular about the approach to interpretation of statutes such as the 2005 Act. You will find that at paragraph 19 onwards of their submissions. Helpful and informative though those submissions are, we do submit that actually this isn't a difficult issue of construction, because in our submission the terms of the legislation are clear, or the relevant terms of the legislation are clear and can I turn first in that context to section 17. Section 17 is found in the bundle of authorities at tab 5, page 43. And it starts in subsection 1 rather, by making it clear that procedure and conduct are a matter for you, sir, to provide directions about, subject, unsurprisingly, to any provision of the Act or the rules. Now, that doesn't, in our submission, mean that the rules, for example, are a comprehensive code. Far from that. What it makes clear in our submission is that the primary source of your powers in relation to procedure are found in the Act. The Act gives you a broad discretion as to how to conduct proceedings, and then the rules, to some extent, obviously, then supplement that. The idea, or the submission rather, that you have broad powers, we submit, is supported by subsection 3. And subsection 3 in our submission is critical for these purposes, because it makes it clear that the one or the primary obligation that you are subject to, sir, is the obligation to ensure that you are acting with fairness. Now, it is true, as has been highlighted, that subsection 3 also references the need to have regard to unnecessary cost, perhaps unsurprisingly. But that is, we submit, a secondary consideration, if I can put it that way. And the reason I say that is that the obligation to act with fairness is an unqualified obligation. It is expressed as being, and that is clear from the use of the word must. We submit, reflects the case law that I'm going to come to, which makes it clear that common law fairness applies in this context. In contrast, the reference to costs is that you are required to have regard to unnecessary costs, or the need rather to avoid unnecessary cost. And that language of have regard and that reference to unnecessary cost in our submission makes it clear that ultimately this isn't a question of balancing fairness against cost. If something is required as a matter of fairness, it has to happen. The only relevant restriction on that requirement in relation to fairness, it arises because of section 19 rather, because section 19 obviously to some extent is a departure from fairness by permitting procedures or hearings to take place without some of the core participants. Now, what we submit is that what section 17 reflects, which is not inconsistent necessarily with other provisions, and I'll come on in particular to the scheme that applied to the parole board that was considered in Roberts. What this scheme demonstrates is that ultimately you are given a broad discretion as to how to act when conducting this inquiry, and that broad discretion is there essentially to ensure that in the wide range of circumstances in which an inquiry may be being held, fairness can be achieved. This is we would submit that Section 17 means that Secretary of State for Northern Ireland is wrong to say that effectively the acts and the rules are a comprehensive code. To the contrary, what we submit is that the scheme is intended to be a flexible scheme to ensure that fairness can be achieved. Section 18 then provides essentially that the default for a tribunal is public access. We submit that, while not perhaps being directly relevant, is an indication of the importance of the inquiry allaying public concerns, essentially, that led to the establishment of the inquiry. it's why the public needs access to the inquiry. Then one comes to section 19. And section 19 obviously is the provision that permits the holding of a closed procedure, but it can only be justified on certain specified, relatively limited grounds. Those grounds are essentially set out, we submit, in section 3b. But before turning to section 3b, it's important to notice that the structure of subsection 3 is that it permits restrictions where justified, but it's the restrictions, it's not the making of the restriction order that it is permitted where the specified grounds in 3b are present. And I make that point for this reason. It would be possible, it would have been possible for Parliament to enact a piece of legislation that essentially said when conditions X and Y are present, the chair of an inquiry can make a restriction order which can contain such provisions as they regard as appropriate. That's not the structure of this piece of legislation. Each restriction has to be justified. And we emphasise that in our submission because based on the case law, particularly the judgment of the House of Lords in Roberts, we submit that the denial of a special advocate is in fact a further restriction on fairness, or a further restriction on the rights of the individual. We say that because when I come to Roberts, we will submit that essentially what Roberts recognises is that a closed procedure represents a significant restriction on basic fairness, and the appointment of a special advocate then mitigates that to some extent, not completely, but it mitigates to some extent. And so ordering essentially a restricted hearing without the presence of a special advocate is a further restriction, we would submit, and so has to be justified. Looking at the potential grounds, I should say I've skipped over subsection 3a because I don't think anyone suggests it applies here. The grounds upon which a restriction order would be made essentially are that it would be conducive to the terms of reference, or it would be necessary having regard to the matters in necessary in the public interest, rather having regards to the matters in subsection 4. Subsection 4 is of relevance in our submission, partly because it identifies two matters that may be said to be particularly relevant to the argument in this case. Firstly, it emphasises the importance of public concern and the impact essentially on allaying public concern. And obviously one of the points we argue is that having a special advocate will potentially contribute to allaying public concern by giving core participants, greater faith or greater confidence in the outcome of the procedure. And secondly, another factor to be considered is the extent to which risk of harm can be avoided by such a restriction. Now, if I'm correct in the submissions I made in relation to subsection 3, and in particular the need to consider separately essentially the justification for denying core participants a special advocate in the context of subsection 3, that suggests that it's necessary to consider the extent to which any harm would be caused by the appointment of a special advocate. And we submit, because of the nature of special advocates' appointments, because of the fact they are security cleared, no harm would result from that. Now, one thing we submit about Section 19 is that it should be interpreted narrowly. The Secretary of State for Northern Ireland, in their submissions at paragraph 38, summarised the principle of legality, meaning that general words cannot undermine fundamental rights. And we would submit that domestically fairness, common law fairness, is a fundamental right, a right which is then safeguarded in Section 17. A closed procedure is inconsistent with that. It's a procedure authorised by Parliament, but it is still a departure from basic principles of fairness. And that implies that provision authorising a closed procedure should be interpreted narrowly. And it certainly shouldn't be interpreted, for example, as meaning that there is no right to the participation of a special advocate if that is required by reasons of fairness. Consistent with that, in our submission, and I won't take you to it, but it's at paragraph 9b of our submissions, we draw an analogy with a judgment that was delivered in the context of an appeal from the Special Immigration Commission, the Queen on the application of E. Russia, 2012 One Weekly Law Reports 3198, which made the point that because closed procedures are a derogation from basic rights, one needs to ensure that further derogations are minimised. And that means in our submission that one should be looking in this context for authority or for some legal basis. And we submit none can be found in the 2005 Act for denying someone the protection of a special advocate. That should be the correct approach to interpretation. Section 19 certainly shouldn't be read as being an implicit basis for concluding that there is no right to a special advocate where Section 19 is applied.
You touched on subparagraph 3A of Section 19,
yes.
Mr. Southey, and rather brushed over it on the proposition that it didn't have any application. But I just wondered whether or not that may be where, for example, any evidence that was caught by the Investigatory Powers Act might fall.
Well, as I was making the submission, I actually sort of wondered for a moment whether that was something, to be frank, I'd missed in relation to it, is that might be... I think that the reason why I think initially I'd reached the conclusion it wasn't where it fell was that there may be a degree of circularity, and the reason I say that is this: if you go to the, I'm looking for the relevant act, I think it's at tab 8 of the authorities, and it's the relevant provisions, I think, are at page 94.
What is it we're looking at here?
Sorry, I'm looking at Schedule 3, I think it is, the relevant provisions that apply in the 2016 Act. The 2016 Act is premised essentially, particularly paragraph 23, on the fact that it provides an exception to the general rule prohibiting disclosures of intercept material where a restriction order is in play, effectively, albeit the restriction perhaps is defined in a particular way. It doesn't require any restriction order to be made. What it does is authorise disclosure if a restriction order is made. So the way in which I would argue...
But paragraph 23 specifically refers back to restrictions imposed by section 19.
It does, but the reason why I'm saying it's not, it doesn't come within 3A, I think, or I submit rather, is this. It provides authority for disclosure where there is a restriction order in play. So it means that there is no breach of section 56 in that context. I would submit that the way in which, in practical terms, this is intended to operate is that suppose there is a piece that you, sir, become aware that there is an item of intercept material that you wish to consider as part of your deliberations. You would make a restriction order under 3B because that was necessary, it was conducive for you for fulfilling your terms of reference. That would then, providing it was made in terms that come within section, that come within the terms of paragraph 23 of Schedule 3, that would then provide you with authority to receive the material and not breach section 56. So you would be making the order not because you're required by the legislature, because nothing in paragraph 23 requires you to make a restriction order. It's just that if you don't make a restriction order, you can't consider the material. And so the way in which it seems to us this operates, as I say, is you make the restriction order under 19.3b because it's necessary for you to fulfil your terms of reference. You need access to that material. Once you've made that order, that gives you the authority to receive the material under compatibly with section 56.
Well, whatever the answer to it is, it probably doesn't affect the point we're arguing today.
I don't think it does, but that's why I think that's why our initial position was it's still a subsection 3b point, but as you say, sir, it may not matter for today's argument. Two things that I should make clear about the statutory scheme that I've just described. The first is that when interpreting it, one needs to consider just how wide-ranging, in principle, section 19 is. Whether or not we are correct to argue that a special advocate should be appointed in this case, the first issue obviously is whether or not you have the power. Now, in principle, it would be possible to have a section 19 order that effectively prevented a core participant in an Article 2 inquiry receiving any relevant evidence about the failings of the state. In this case may come close to that, given how important intelligence is, but in principle it would be possible to have all of the hearing about state failings enclosed. When I come to the Article 2 case law, if that were to be the case, in our submission, it's difficult to see how it could be compatible with Article 2 for the inquiry in those circumstances not to appoint a special advocate, particularly when there is no obligation necessarily to put in place a counsel to the inquiry. There is no obligation necessarily for the inquiry to be chaired by a lawyer. And so when looking at the powers in our submission, given how Section 19 in principle could be used, it would be surprising in our submission if there isn't, in the right case, a power to request the appointment of a special advocate. The second point is, and it links into some of the case law considering fairness in this context. One of the points made by counsel to the inquiry this morning was essentially whether common law questioned whether common law fairness essentially could override statutory restrictions, such as it was suggested are found in the Inquiries Act. Our point is not that the common law can override in some way the provisions of the Inquiries Act. It is that Section 17, particularly Section 17.3, expressly preserves the common law fairness rights that would have been enjoyed had this inquiry been established on some other basis. And that, we submit, is reflected in the case law. We cited in our initial application a number of cases considering common law fairness in this context. They, to some extent, are considered and summarised in the recent judgment from the Court of Session, the Greater Glasgow Health Board case, which is at Volume 2 of the Authorities, tab 45, page 1245. And the relevant passages are found at, as I say, 1245, paragraph 33. And there Lady Wise recognises that fundamental principles of natural justice apply to inquiry proceedings. We submit, unsurprisingly, given Section 17. And she recognises that those are requirements that apply to both adversarial and inquisitorial hearings. That's important in our submission because a certain amount of weight has been placed in some of the submissions on the fact that the inquiry is clearly inquisitorial. And that's correct, but it doesn't, as this authority and earlier authorities make clear, mean that there isn't a need or a right to be heard and a right to present argument and evidence, as is made clear in the Greater Glasgow Health Board case. And that doesn't mean that there isn't, as I say, analogous rights to those rights that are found in relation to adversarial hearings. Now, as I say, Lady Wise's judgment at the bottom of the page makes it clear that the rights, the natural justice rights that arise include the rights to present relevant argument. That is qualified, obviously, in this context by Section 19, but that's where a special advocate, we submit, potentially comes into play, because the special advocate is in a position to present argument. I'll come on to why we submit they're in a better position to present argument than counsel to the inquiry. What is also...
Is the context of the Greater Glasgow Health Board case important for the consideration of the presence of some sort of natural law right?
I'm not sure it is sir, in my submission, in the sense that what it's identifying, the link, just in one sense to footpath where to point out where I'm intending to go in relation to this. Our point is that Section 17 essentially expressly provides for the protection of common law fairness, or the preservation of common law fairness. The factors that we submit, the cases where special advocates have been found to be necessary, the factors that have led to the recognition of a right to a special advocate are essentially two. They are, firstly, that there is a power for the court or tribunal to hold proceedings enclosed, and secondly, then, the obligation to ensure fairness. And so all I need for these purposes at the moment is to demonstrate, essentially, that the inquiry, perhaps unsurprisingly, but it's an important starting point, the inquiry here, we recognise, has the power to hold hearings enclosed, but also has the duty to ensure fairness, and in particular common law fairness. And so, yes, the context was very different. There isn't, as far as I'm aware, and as far as I think anyone's aware, any authority dealing expressly with the issues that arise in this context, other than the decisions of previous chairs, the 3 decisions of previous chairs. But there's no, certainly no judicial review, for example.
The question must be, what does fairness mean in any given situation?
Well, that's where I go on to build on that with the context with the cases that deal with special advocates in other contexts.
But if we look at, before we leave it, if we look at the Glasgow Health Board case and the cases which preceded it, the concept of natural justice was brought into focus by the fact that, for example, in Glasgow Health Board, the chair was likely to make a critical finding against a party who was not being permitted to lead evidence that might have dissuaded them from making that finding.
Yes, that's correct, and
a very obvious focus for natural justice, but it's not necessarily going to take us terribly much further in understanding what fairness means in other contexts.
Well, except the fundamental the 2 things I'd say in relation to that. Firstly, if one looks at the passage from that I've taken you to from the Greater Glasgow Health Board case, I accept, of course, that where someone's reputation, for example, is an issue, that is an obvious circumstance in which fairness can apply. But the statement of principle, which was cited from Mahon by Lady Wise, indicates that a person represented at an inquiry whose interests may be adversely affected enjoys the rights to natural justice that I've just been talking about. And if you think about the position of a core participant in, such as the core participants I represent, they are obviously represented, and they're represented because, in part, they may be adversely affected by the conduct of the inquiry. If the inquiry ends up reaching conclusions, essentially, that those I represent haven't lacked confidence in, that, from their point of view, it means that the long road they've been on, seeking justice, hasn't yet come to an end. They are adversely affected. They have an interest. They have a very real interest in ensuring that the process is robust. Now, linked to that...
But that's not the same kind of adverse interest that was being discussed in these cases. In Mahon, for example, there were financial penalties imposed, and there were criticisms, and there were accusations of conspiring to pervert the course of justice. Now, the kind of adverse consequences that exist in that case and in Greater Glasgow Health Board cannot possibly arise in the course of this inquiry. There can be no circumstances in which any of the family core participants can conceivably be criticised in the context of the inquiry exploring its terms of reference.
That's correct. I mean, nobody would suggest they could be criticised, I would hope. But the point I'm trying to make is that at this stage, it's important in one sense to take the issue stage by stage. The first issue is: do they have? Do the core participants I represent have a right to a fair procedure? And that's, in one sense, all I'm seeking to establish at this stage. And the interest may be different, and that may have an impact on what fair procedure amounts to. But certainly their interests in our submission are sufficient to mean that they have a right to a degree of fairness. That's implicit, for example, in the status of core participant, because that means obviously they have a right to legal representation, they have various other rights under the rules in relation to that. All of that recognises they have some right to be heard. And that's, in one sense, all I'm worrying about or making submissions about at this stage, because that is the if you like, the foundation I need to then go on to look at what the case law says about the values of special, or the benefit of special advocates being present. Can I also just can I come back to that in a moment, because I was going to take you to the Osborne judgment, and the Osborne judgment looks at the purposes of fairness, and that supports my arguments in relation to that. But before I do it, can I then just draw attention to the, partly because it means we don't have to go to the underlying authority, the citation by Lady Wise in the paragraph I've drawn attention to of the Associated Newspapers judgment, the judicial review of Lord Justice Leveson's inquiry, which emphasises that when looking at the issues of fairness, we would submit what it emphasises is that public perception is important, and public perception requires that the inquiry should be, among other things, as balanced as possible. And I make that point because one of the concerns, in one sense, about the closed procedure, which is one of the bases upon which it is submitted that a special advocate is required, is that if the closed procedure does not involve a special advocate, diligent though counsel to the inquiry will be, we're sure, there will be something of an unbalanced process. And one reason for that is that whatever happens in closed, if lawyers for state parties are present, they will know whether or not there is a legal error that they wish to challenge. One of the difficulties, and it's one of the reasons why we submit a special advocate is important, is that in contrast, the court participants I represent will not be in that position. There will be an inequality of arms, and to that extent, a lack of balance. Now, I mentioned a moment Osborne, and it's important when considering that because it perhaps sheds light on this issue of sort of whether or not there's a meaningful distinction in this context between people who perhaps are at risk of criticism, maybe at risk of losing jobs, etc., because of those criticisms, and the court participants I represent. And in Osborne, which is at the relevant passage starts at page 875. Lord Reid considered what the purposes of procedural fairness are. And he identified, essentially, we would submit 3 purposes. The first is essentially ensuring that better decisions, or contributing rather to the achievement of better decisions, and you see that at paragraph 67 of his judgment. And we would submit that a special advocate potentially brings that benefit because they can have detailed instructions, they will have detailed instructions, and they'll be able to present, for example, legal arguments on behalf of court participants. They can present, for example, legal arguments that may be difficult, but still arguable. And obviously argument assists the inquiry. If you hear 2 sides of an issue, it's hopefully more likely that a better decision will be reached. But it's important to recognise that Lord Reid went on to emphasise that there are at least 2 other values that are engaged. And the first of those is particularly important. And Lord Reid deals with that at paragraph 68. And that, he starts by describing using language of Lord Hoffman, but in fact then says he prefers to describe it in slightly different terms. And the language that Lord Reid uses is it references the sense of injustice, namely that justice is intuitively understood to require a procedure which pays due respects to persons whose rights are significantly affected by decisions taken in the exercise rather of administrative or judicial functions. Now, that sense of injustice, if one looks at it in that context, that sense of injustice, we submit, is likely to be, or could potentially be, present in this context. If one has a special advocate, or rather if one is denied a special advocate, one sees decisions being taken about things of real importance, things that in this context people have been campaigning about for 27 years, without someone who is there specifically safeguarding their interests. One thing just as an aside, because it just struck me, going back to the question my Lord asked me about Greater Glasgow Health Board. just, I realise one thing I should have said partly is that, of course, at this stage, I'm still dealing with the issue of whether you, sir, have a power at this stage. I'm not dealing with the issue of whether or not and that's the primary issue I'm dealing with at this stage. Now, you made the point, sir, that the core participants I represent aren't facing criticism. It's perfectly conceivable that an inquiry could involve a situation where someone is facing personal criticisms, but yet isn't necessarily security cleared, able to access the closed procedure. And so to the extent it might be said that fairness is limited in this case, that's not necessarily a reason for concluding that the power doesn't exist.
Well, the point you've just touched on is the one made by Sir John Saunders in the Manchester Arena inquiry. I'm not myself entirely sure that a special advocate is the answer to that point, but we can put that aside for the moment.
Well, I come on to the role. I mean, I'm only going to come on to what we say the role of the special advocate is and why they're potentially important. But I just it is just important to recognise that in terms of what there's a need to distinguish between, in one sense, what common law fairness could require in this context and what it may require in this context on the facts of this case. Going back, though, we do submit that sense of injustice. And can I just draw attention to, linked to that, Lord Reid went on to consider those issues, this issue of the importance to, what I would describe as the importance to the individual of being seen to be treated fairly. And he deals with, he goes on to, and can I just draw attention to paragraph 70 in particular, where Lord Reid referred to the practical consequences of the sense of injustice and cited Lord Phillips, who said, the feelings of resentment that will be aroused if a party to legal proceedings is placed in a position where it's impossible for him to influence the result. That's important in our submission in this context. Going back to where I started from and the campaign that is a number of the core participants I represent have been involved in for a lengthy period of time, that sense of resentment described by Lord Phillips is a real concern if, having campaigned for so long, key findings are made in circumstances where the core participants believe that their ability to influence the outcome has been restricted because of the fact they've not been able to instruct a special advocate, in circumstances in particular where the special advocate has in the past been heavily involved in litigation that led to this inquiry. Now, the second value or the second benefit of a fair procedure that Lord Reid identifies essentially is in para 71 of the judgment, and that is congruence with the the second value, rather, is the rule of law, as he describes, and what he means by that is congruence between the actions of the decision maker and the law governing their actions. How is that relevant in this context? Well, it is certainly conceivable that there will be a legal argument, essentially, enclosed, potentially about issues to do with evidence, for example, and what evidence is required and what evidence is needed to ensure the inquiry fulfills its role. having someone present those legal arguments in closed on behalf of the court participants potentially does promote the rule of law in the way that Lord Reid is describing. Can I just also touch on, before leaving the authority, so that I don't need to go back to it, given that issues have been raised about cost, at para 72 of the judgment, Lord Reid deals with an argument that was presented in Osborne about cost and about the cost of the parole board of holding oral hearings. And halfway through paragraph 72, Lord Reid says this. He says, the easy assumption that it is cheaper to decide matters without having to spend time listening to what the person affected may have to say begs a number of questions. And what Lord Reid emphasises then in the following lines of para 72 is that one of the problems with making that assumption, that it's cheaper essentially to have a simplified procedure, is not necessarily accurate because of the consequences of a wrong decision. And there is an analogy here which makes it clear, makes the assessment of cost in our submission difficult. If you think about the circumstances of this case, or this inquiry, where there's been the lengthy campaign that there's been for justice, the reality is that what the inquiry is plainly needing to aim at, and what it's in every interest for the inquiry to achieve, is a process whereby everyone walks away from the process feeling confident in the outcome. And adopting a procedure that has the potential to undermine that, by meaning people lack confidence in the process, has the potential to create further cost by essentially resulting in calls for further inquiries or further investigations. It is important that the process is thorough and fully involves the court participants, because that is the way in which essentially there is confidence in the process, and hopefully people can move on, as we indicated in our opening submissions last month. Now, all of what I've just said is the context in which one should regard the case law regarding special advocates. And as already sort of in one sense touched upon, we submit that when one looks at that case law, the basis upon which it is consistently being concluded that a power to appoint a special advocate, the basis upon which those conclusions have been reached about the powers to appoint a special advocate are essentially 2 points. The first of those points is that there is a power and a need to consider material enclosed in the absence of one of the parties. That is always going to be a significant concern, because it obviously raises issues about fairness. But it's an important starting point, because it means that it is, in our submission, in those circumstances, a step that enhances fairness, as Lord Wolfe made clear in Roberts, if a special advocate is appointed. And so the second factor that has led to conclusions that there is a power to appoint a special advocate is essentially the fact that the courts who had this power to hold a closed procedure also had a power and a duty to ensure fairness. And so the reason why the power to appoint a special advocate in those circumstances was found to exist was because it enhanced the rights of the individual who was being denied access to the closed material. It didn't restrict those rights. Both of those factors are present, we say, in this case. We say it's clear, obviously, that Section 19 enables the inquiry to hold a closed procedure, but Section 17 preserves the right to act fairly. Now, turning to that case law, the case law I'm going to draw attention to, it is important to recognise, given what is said about the absence of any reference to special advocates in the Inquiries Act, that the power to appoint a special advocate has been found to exist in a very wide range of circumstances. It exists in crime, it existed in civil proceedings. I say it existed in civil proceedings because it may well be the case that the Justice and Security Act has now effectively codified that. And it exists in family proceedings, and it exists in all those circumstances, as I say, without statutory procedure. And that's not surprising, because in all those contexts there may be the need to withhold material, and yet there is obviously a duty to act with fairness. Dealing with those cases in chronological order, the first of the authorities, essentially, that I would draw attention to is the Queen on the application, the Queen versus H, which is found at tab 17 of the authorities, and the relevant, and the judgment starts at page 199. The issue in that case...
Where are we in your written submissions, Mr. Southey?
Sorry, I'm sort of taking them out of order, but they are, it's in our initial application. Sorry, it's in our application at
it's all right. I'll just go to the case.
Sorry. Yes. Sorry. I think it's at paragraphs in the initial application at paragraph. I can't find it actually. Sorry. I thought it was about paragraph 9, but I'll come back to you if it would assist. But H is at tab 17. Page 199, and the issue was the appointment of a special advocate in PII proceedings. That may be of some significance because, in one sense, the issues for the special advocates in that context would be more limited than in this context, in the sense that it wasn't about the substantive outcome of the proceedings, it was rather about the procedural matter, which was whether or not material could be withheld from the proceedings. It was clear there was no legislation, and you see that if you go to paragraph 22, page 215. This is the judgment of Lord Bingham. But if you go right to the bottom of the page, you see the start of the key paragraph. And I take you to this in part because it explains why the power was found to exist, but also because it may be relevant to another issue that I'm going to need to come to, which is the test to be applied when deciding whether to appoint a special advocate. And you'll see at the last line of the page, Lord Bingham said this: none of these problems should deter, and the problems were some of the difficulties understanding how a special advocate would work, or not understanding how a special advocate would work, but some of the limitations essentially on the work of a special advocate. But you see Lord Bingham saying this: none of these problems should deter the courts from appointing special counsel where the interests of justice are shown to require it, but the need must be shown. I emphasise those words because in our submission they are relevant for two reasons. Firstly, they demonstrate that the basis upon which the power was held to exist, despite the absence of statutory authority, was the need essentially to protect the interests of justice, or, to use the language found in section 17, the need to act with fairness. And secondly, because when looking at the test in our submission, that is really the key issue in this context, whether or not it is the appointment of a special advocate is in the interest of justice, whether it achieves fairness. The next sentence then, obviously, is such an appointment should be exceptional, never automatic, a course of last and never first resort.
Is it of any relevance, or does it make any difference that the interests of justice in the case we're looking at required the court to comply with Article 6?
On the face of it, not necessarily, partly because the structure of the judgment suggests that Lord Bingham reached this conclusion before effectively coming on to his conclusions about the application or the relevance of Strasbourg jurisprudence. And what we would submit on a fair reading, actually, what Lord Bingham's concern really about Strasbourg jurisprudence was whether or not, in fact, the process would still be compliant with Article 6. He wasn't holding it was necessary for Article 6 purposes. He was looking at whether or not, in fact, the process was compliant with Article 6.
Well, maybe if we just call it a fair trial then.
Sorry?
Maybe if we just call it a fair trial then.
Well, I mean, in one sense, the way I would submit that one should approach this, and it goes back to perhaps the submission I made about Greater Glasgow Health Board, is the first question is, in principle, could a power exist? And we submit that if you were to conclude, and this links into the second question, which is the next question, which is what test should you apply? If you were to conclude, sir, that fairness required the appointment of a special advocate, then we submit that that's why the power exists. The question may be, then arises on the facts of this case, does fairness require that? But at this first stage, the point we're making is that the power is said to have been derived from the need to ensure fairness.
But what I'm wondering about is whether this concept of fairness is something that you can just put on the shelf and look at and it never changes, or whether fairness in the context of, say, a criminal trial, or in the context of another case where an individual's rights are being determined, is something that has to be viewed in the context of that process and in the context of what is being determined.
Well, I think it would be a bold submission of mine to say that fairness doesn't, to some extent, depend on context. That's recognised. If one goes back to Doody, for example, in the House of Lords, it recognises that fairness is context specific.
And fairness in the context of a criminal trial requires very obvious and very well recognised procedures, including full disclosure, opportunities to cross-examine, opportunities to lead evidence. And the question in my mind is whether any of these cases which deal with what fairness requires in those contexts has any application to what fairness requires in an inquisitorial process where we're not determining somebody's rights, we're carrying out an actual investigation.
Well, I think I'd make two...
I don't mean to suggest for a moment that fairness doesn't apply.
Yeah.
I'm just trying to understand what help I get from those other cases in understanding what I have to view as fairness.
Well, can I submit that you potentially get three that there are three things that potentially are of assistance from H. Firstly, and to some extent we're adopting the structure to the issues that was set for us by Counsel to the Inquiry. The first question is, as a matter of principle, do you have a power to appoint a special advocate? And if we are correct that at least at least conceptually, a special advocate can be required as a matter of fairness, depending on the circumstances of the case. Then, in our submission, you do have that power. And the fact that conceptually a special advocate can be required indicates, we submit, that the power potentially exists. The second reason, sort of point that we derive from this is that when looking at whether or not a special advocate should be appointed, and there have been various tests put forward in various submissions as to what the test should be, but we submit that the key point to draw attention, the key point to draw from this case law is that the focus should be on fairness. The third point, and this is probably the most relevant, though, in one sense, given the need to consider whether or not there should be a special advocate appointed in this case or in this inquiry, is that what it recognises, because of the context, is the potential value, and you see this also. The other passage I was going to draw attention to is para 36. You see this in para 36, and I'll come to that in a moment. But I'm going to come to, later on in my submissions about what value a special advocate brings. And what this demonstrates is that one of the key roles a special advocate potentially undertakes is that they challenge state justification for withholding material. The whole reason why a special advocate was found to be of value, essentially, to fairness, was because they brought, or they provided a mechanism, essentially, by which the defendant was able to challenge the withholding of material. And that's an important role in this context. Yes, this context is very different. It's not a criminal trial, but one of the key things that we submit court participants have a legitimate interest in is ensuring that as much as possible is brought into open. And what the H judgment demonstrates in our submission is the potential importance of the potentially important role that special advocates play in that context. The reason why they potentially add to fairness is they provide, they potentially challenge the state when it seeks to withhold material, and
that's what I would do in an inquiry, and that's what counsel to the inquiry would do. And the difference is that in an adversarial situation, such as we're discussing in R, one party is seeking to withhold information, the other is arguing for disclosure of it, and the judge knows nothing about it. He sits in the middle and determines as best he can as between the two. But in the context of an inquiry, I will know all of the information. I see all of the material. I see all of the documents. Counsel to the inquiry will argue for disclosure as and when it's appropriate to do so, and so will I. So I don't for a second dispute the importance of fairness, but I do struggle to see how the comparison with R takes us terribly much further.
Well,
complete difference between an adversarial and an inquisitorial system.
I'm going to come on later to counsel the inquiry in particular. I mean, I recognise the limitations in the limitation, or the limit to which I can take my reliance on R&H. The reason why, the reason why, in one sense, we start with it is because it is an indication. It does certainly undermine the suggestion that the statutory authority is needed for the appointment of a special advocate, and it indicates the special advocate can enhance the rights of someone who has been denied access to the material. And I maybe can take it no further. I recognise that it's not directly on point, but all I would just draw attention to, para 36, the reason I drew attention to para 36, and particularly sub-paragraph 4 within paragraph 36, is that para 36, it demonstrates, or is where Lord Bingham sets out the potential value, essentially, for of a special advocate in essentially challenging the state's justification for withholding material from a defendant, or the prosecution's justification for withholding material from the defendant.
Paragraph 36, did you say?
Paragraph 36, particularly sub-paragraph 4, and it's the end of sub-paragraph 4.
Sorry, are we still in Osborne? Sorry, I'm looking at the wrong case now. I'm so sorry.
Sorry, it's page 220, I should say.
Well, I've moved on to a different case. I'm sorry. Can you give me the PDF number for this?
Sorry, yeah, page 220 of the PDF.
Sorry. Yeah. What is it you want me to take from that, Mr. Southey?
What I was going to what I take from that, particularly the last 6 or 7 lines of that, which is talking about the testing of contentions of the prosecution, essentially, in relation to justification for withholding material. It was really the passage I relied upon to make good the point I was making earlier, which is that special advocates can provide real assistance in testing justifications for withholding material.
If you're finished with RVH, we can perhaps think about breaking off at this stage and
Certainly.
maybe sitting again at 1:45. Would that be convenient?
Yeah, that would certainly be very convenient, yeah. Chair, thank you. Where we broke when I think I'd finished making submissions essentially about the Queen and H. I should say, having sort of thought about your remarks overnight, not overnight, over lunch, that none of the authorities I'm about to go to expressly deal with, in one sense, the issue of what fairness requires in these circumstances. And so, to some extent, they may not provide a direct answer to the to the question that you were asking. What they all effectively go to is the potential value of a special advocate, and in particular the potential value of a special advocate in ensuring fairness. Now, as I say, the next in line chronologically, and possibly the most important, is the Roberts judgment. And the Roberts judgment is Volume 1, Tab 19. Relevant passages starting at page 260. And the reason why the Roberts judgment is potentially of greatest significance is because probably there's the closest. It's probably the closest analogy to the situation here for two reasons we would submit. Firstly, there is a degree of overlap between, or there's a degree of similarity between the statutory scheme in issue and the statutory scheme that was considered in Roberts. And secondly, because it was what was described at the time as an administrative body that was in issue. And so it wasn't regarded, certainly at that stage, as a classic court. To make good those first 2 points, firstly, if you go to page 260, you will see at the bottom of the page...
Mr. Southey, is it possible to use the paragraph numbers in Roberts?
It is. I was going to go to... It's paragraph 21...
It's just I'm using a version of my own that I've already marked up.
Well, yes, that's the version is in a slightly odd format at the moment. So para 21 sets out with para 22 some of the statutory framework, and the provision I was going to draw attention to is probably about 2/3 of the way through paragraph 21. And that's Rule 13.2 of the Probable Rules that applied at the time, which made it clear that the panel had to conduct a hearing in the manner that it considered most suitable and for the clarification of the issues, and generally to the just handling of the proceedings. And so there was basically a requirement to act justly. That was consistent with a common law rule of fairness, or common law principles of fairness, rather, which also applied. So you had a general power to act to ensure fairness.
Which rule are you referring to?
13.2. As I say, it's about, on the version I've got, there's a lengthy quotation or citation rather of Rule 5, I think it is, and then there's, after that citation, there's a passive paragraph that starts, there was to be an oral hearing of the prisoner's case unless otherwise agreed.
Yes.
And then it's within that you'll see 13.2.
Yes.
If you then go on to the next paragraph, because the rules had changed from time to time, you will see there a citation of Rules 6.2 and 6.3, and you'll see in 6.3 there was an express power to withhold material from the prisoner and indeed from their legal representative. And you see that the power to withhold from the legal representative it arises because there was the power of the chair to direct otherwise. The default was effectively disclosure to the prisoner's representative, and but there was a power to direct other than in accordance with that. And that power to withhold it from the lawyer was confirmed effectively by Lord Wolfe. If you go to paragraph 75 of the judgment, you will see Lord Wolfe, in his judgment, saying, although it's not entirely clear, it is his view that rule was intended to allow the chair to authorise the material to be held from the lawyer. So the reason, as I say, why I draw an analogy is that you have a general power to ensure fairness, and you have a specific power that allows material to be withheld from the prisoner. And that's important when I come to the detail of Lord Wolfe's judgment in particular. Now, consistent with the general power to order fairness, if you go to paragraph 56, you will see Lord Wolfe indicating that there was, and it's probably 2/3 of the way through paragraph 56, that there is an implicit obligation on the board, to act fairly. So as I say, you have that combination. Now, in that context, what Lord Wolfe concluded was that the instruction of or the appointment of a special advocate was acceptable or lawful because essentially the use of a special advocate provided additional protection. And you see that paragraph 57, about, I don't know the size of your type, but probably about 5 lines into it, Lord Wolfe noted the criticism of special advocates in bodies like the Special Immigration Appeals Commission, but distinguished the current situation because it was a situation where the special advocate was providing additional protection. He then, in paragraph 58, at the end of paragraph 58, cited the European Court of Human Rights judgment in Chahal, where the European Court had talked about how there are techniques, essentially, that can accommodate security concerns while providing a substantial measure of procedural justice. And effectively, at the start of paragraph 59, endorsed that reasoning, providing that special advocates do not reduce fairness. Then considered the argument, which to some extent is reflected in some of the submissions that have been made to you, sir. At paragraph 61, he considered the argument that there was no statutory authority distinguished them on the basis that in this context, the use of a special advocate would be exceptional. Certainly, we would say it would be highly unusual, obviously, in the context of inquiries, given the history of inquiries. But noted that the position in relation to the model rules for tribunals was that there was no provision for special advocates in those rules, but there was a possibility of a closed procedure. So suggesting that the situation faced in Roberts and faced in that arises in this case is not necessarily without precedent. And expressly said this, which may be of relevance, that the absence of rules may not be a disadvantage. It enables their use to be flexible. And that's important in this context. Going back to the legislative scheme, potentially we would submit, because of the wide range of situations in which inquiries may need to be conducted, it is deliberately not prescriptive. But that is an advantage potentially in this context, because it allows the inquiry to effectively develop a protocol for the use of a special advocate that reflects the particular circumstances of this case. Now, the prisoner in Roberts, linked to that issue, the prisoner in Roberts opposed the use of special advocate and argued effectively that the role of the, which again is sort of similar to some of the arguments that have been presented, that the role of the parole board was constrained by statute. And you see that at paragraph 65. And what Lord Woolf then does, having noted that in principle the submission was correct, drew a distinction which may explain the provisions of the Inquiries Act. He drew a distinction between the withholding of information, which was expressly provided for in the legislation and in the parole board rules, and the power to appoint a special advocate, which he said arose because there was an implied duty to act fairly. And if that approach was adopted, Lord Woolf's opinion was there was no objection, because the special advocate essentially is only mitigating the disadvantage which would otherwise be present. And that's one of the reasons why we submit the structure of the legislation in this case. It supports our arguments, because what it does is it gives express authority for a restriction on what would otherwise be a right through natural justice, which is the right to be present while the hearing is taking place, and the right to participate in that hearing. It doesn't then deal with special advocates because there is a general power to ensure fairness. And the use of the special advocate, consistent with what Lord Woolf was, the approach of Lord Woolf, was to distinguish between the withholding of information and the appointment of the special advocate, because a special advocate mitigates unfairness that would otherwise be caused by the withholding of information. Lord Roger was in the majority as well. It was a 3-2 majority, the Roberts case. And he did so, if one goes to paragraph 109 in particular, on the basis that there was justification for withholding material. Special advocates, as a result, mitigate the unfairness. It's really the end of para 109. So what I submit in relation to this is what this demonstrates is, and I accept it doesn't answer the question that my lord, you sir were putting to me this morning, which is effectively, well, why can't Counsel of the Inquiry carry out these functions? But what it demonstrates is that the structure of the Act should be understood essentially as, in this way, it obviously expressly permits the holding of a closed procedure, despite that being a departure from normal principles of fairness. It then allows for, or requires, the procedure to be as close to fair as possible. In doing that, it does implicitly give the inquiry powers necessary to achieve fairness, and to the extent that requires the appointment of a special advocate, then a special advocate can be appointed. That's why, for example, Pierce and I think it is, make reference to the Al-Rawi decision, which was the decision that held that there can't be an implied power to hold a closed procedure. But that doesn't say it doesn't assist in our submission, because that's the first stage. There is undoubtedly an express power in this context. The question is, what can be done to mitigate it?
I'd like to just think about Roberts for a moment, if I may, because I think throughout all of the discussions about the possibility of appointing a special advocate in inquiry proceedings, Roberts has been identified as an important case.
Yes.
All the way back to at least Sir John Saunders' decision in Manchester. Yep. It's founded upon here as well, and I think some see it as perhaps the straightforward answer. It's something of a nuanced case. It starts off as a 3-2 decision of the House, as you say. But the basis of the decision was twofold, I think. As you say, first of all, the court held that there was an express power to withhold the documents from the prisoner himself and from his representatives. Yep. And then they turned to see what could or should be done about that.
Yeah.
And one of the relevant provisions was Schedule 5 to the Criminal Justice Act of 1991, which I think we see set out in Lord Carswell's decision at paragraph 116.
Sorry, I've just... 116?
Yes.
Yeah.
So the 1991 Act was the Act which set up the Parole Board.
Yeah.
And that was then amended by the Crime Sentences Act of 1997, yeah, which was the act which gave to the board the responsibility for determining whether or not a life prisoner should be released, whereas originally the only power they'd had was to make a recommendation.
Yeah.
So the board is given the power in respect of somebody like Mr. Roberts, who'd passed his tariff period, to determine whether or not he should be released. And we see from paragraph 116 that Schedule 5 may have a role to play in that, because it tells us that it shall be within the capacity of the board to do such things and enter into such transactions as are incidental to or conducive to the discharge of its functions under the 1997 Act. And for Lord Roger and Lord Carswell, that, I think, was the triggering provision. If we look at paragraph 107, for example, we can see that Lord Roger begins by saying that there's power within Rule 6.3 to withhold the provisions, and then he looks at what has to happen after that. And he says that at the end, in purely domestic law terms, in making an appointment, special advocate, the board act within their powers under 32(7) of and paragraph 12b of Schedule 5 to the 1995 Act. And Lord Carswell at 131, I think, says the same thing. So he says that it seems to me that the board can more simply and easily satisfy the test contained in paragraph 1(2) of Schedule 5 to the Act, which provides it's within its capacity to do such things as are incidental to or conducive to the discharge of its functions. The functions of the board are to assess whether it's safe to release, and so on. If the only effective way to get that information from the reluctant informants is to use the specially appointed advocate procedure, then the use of that procedure is incidental to or conducive to the discharge of its functions. And as you've drawn attention to it, paragraph 65, Lord Wolfe's view was that there was an implied duty to act fairly in undertaking the duty under the 1997 Act,
yep,
which is the duty to determine the question of whether or not the prisoner could be released. And so what we can see is that two of the judges concluded that the board had power to do such things as were incidental or conducive to its functions, and the other held that it had to act fairly in carrying out its functions. And it therefore seemed to me that it might be important to understand what function the board was undertaking in the context of that discussion, and what the appointment of the special advocate was conducive to. And it might be important to understand that the prisoner in Roberts was someone who'd passed the point of minimum term, and that gave him two important rights. The first was to be released if judged to present no continuing threat to the safety of the public. That came from the 1997 Act. And the second was to bring proceedings to challenge the lawfulness of his continuing detention, which comes from Article 5(4). And in the exercise of these rights, particularly the first, he's entitled to procedure which reflected the importance of what was at stake for him. That's the way Lord Wolfe put it at paragraph 46. But it's perhaps also important to understand what he's entitled to in respect of his Article 5(4) rule, 5(4) right rather. And we see that at paragraph 135, because it's something a little more prescriptive. At 135, we see that Lord Carswell is explaining that Article 5(4) was engaged by common understanding, and he says a prisoner whose tariff period has expired is entitled to have his continued detention decided by a court, and for these purposes the parole board has the essential features of a court. An adversarial procedure involving oral representation and the opportunity to call and question witnesses is required. And Lord Bingham, although dissenting on the outcome, said precisely the same thing at paragraph 17, namely that there was a necessity for an article, in an Article 5 context, for there to be an adversarial procedure. And so the context that the board was dealing with was, if there was no representation for the prisoner, and if the prisoner was not given access in any sense to the material which the Secretary of State wanted the board to rely on, then the procedure before the board could not have been Article 5 compliant. the board could not have decided as a court whether or not it ought to order the release of the individual unless it was doing so in the context of an adversarial procedure with an opportunity to call witnesses and lead evidence. And it was therefore necessary for something to be done in order to create an Article 5.4 compliant procedure. And what was done was the next best thing, namely to appoint a special advocate. And so, whilst the board was able to exercise powers which were conducive to its function was to operate a court and to provide an adversarial system. Now, I'm not sure how that translates to what we're talking about.
Well, can I answer those points as best I can? Firstly, in our submission, although it is true, and there's reference to it in the judgment, that the parole board was required to function in accordance with Article 5, the primary reason given in my submission was domestic law, because of the domestic law obligation to ensure fairness. This wasn't a case where the House of Lords reached a conclusion as to what domestic law required and then said, hang on a minute, we have a problem here with Article 5, we need to interpret this in a different way. The analysis of all the judges in our submission focuses primarily on domestic law, and Article 5 is then noted in passing, in part because...
There's no difference between Article 5 and a domestic law. The parole board has operated under compliance with Article 5 for goodness knows how long.
Well, it hasn't always complied with Article 5 because of the role of the Secretary of State. But by the time, certainly by the time Roberts was considered, it was seeking to comply with Article. The point I was making was that and this was not incompatible with Article 5, but a lot of the reasoning and the passages I took you to, for example, from Lord Wolfe, were focused on reaching a conclusion actually that, as a matter of domestic law, there wasn't an issue here, that the power to appoint a special advocate arose. Now,
but that was because of the duty, in Lord Wolfe's view, to act fairly in determining the decision as to whether or not the prisoner should be released. So, as he put it, the prisoner was entitled to a procedure which fairly reflected the importance of the process for him.
Absolutely. And my Lord, I think I started this session by making it clear that I recognise the limitations, in one sense, of these authorities. What I rely on this as authority for is the principle that in circumstances where there is an express power to withhold material from a party to some form of proceedings, and that results in unfairness, the use of a special advocate can, to some extent, mitigate that unfairness. I recognise that, in particular, this doesn't deal with the situation in this case where, firstly, I have to accept, obviously, it's not concerned with the liberty of the individual, and secondly, it doesn't say anything about the extent to which the role of counsel to the inquiry, because there was no one in that role. It says nothing about the extent to which the role to counsel to the inquiry can also mitigate the potential unfairness that results from consideration of something enclosed. All, in one sense, maybe. Not maybe. The primary purpose for relying on this authority is because it goes to this first issue, which is, does it matter that there isn't any express provision in the legislation? That's something that counsel to the inquiry has focused on. And we say, no, it doesn't, because actually Roberts has a very similar structure. It is considered a very similar structure. It was a situation where there was undoubtedly a power to withhold the material, and there was then a general duty to act fairly. Now,
well, there was a power, a statutory power, to do what was necessary, to undertake what steps were necessary as conducive to the function of the board.
And that was in circumstances where the board had to act fairly, so it could do what was necessary to ensure fairness. I was going to say that one of the points I was going to come back and make a submission about was that my Lord has distinguished to some extent between the judgment of Lord Wolfe and the other two judges. I think it's Lord Roger and Lord Carswell. I would submit that distinction is not necessarily as clear as it might be, in the sense that my Lord made the point, or it might appear, because my Lord made the point that Lord Carswell in particular highlights the legislation and the provision saying effectively the board had powers to do what was conducive to its functions. That raises the question of what are its functions, and one of its key functions is clearly to act fairly, which is a route to...
Well, I'm not so sure about that. I mean, its function is to determine the rights of the prisoner, and in doing so, it has to act fairly. It's not just got a function of acting fairly without qualification. Its function is to make a decision which affects the prisoner, and in doing that, it has to act fairly. I don't really see there's much difference between any of the three of them.
No, I was going to say that, but I agree with. I would certainly adopt that there isn't very much difference between them. But then that if you look at obviously the structure of the Inquiries Act is not entirely identical to the statutory structure that governed the parole board. But when you look at the structure here, you still have the power to decide how to conduct the inquiry in general terms. I can't remember the exact legislation, but that's broadly a fair summary we would submit. You have to do that in a fair manner, because that's what Section 17(3) says. And that means, in our submission, it must naturally flow, and that is where there's the overlap with Roberts. That means that you must have, in our submission, the power to appoint a special advocate if that's necessary as a matter of fairness. And it goes, what this goes to is two things, really. One is, do you have the power? Secondly, if you do have the power, what tests should you apply? And we've very much focused on fairness. Now, it doesn't go very much further than that, because obviously you've highlighted there probably are more differences, but there are at least two differences. One is the fact that liberty isn't an issue in this case, so Article 5 isn't an issue, albeit Article 2 is obviously an issue. And secondly, there was no equivalent to counsel to the inquiry, and they're both matters I need to address. But so I recognise there's a limitation to Roberts, but to the extent, and it is relied on particularly by the Secretary of State for Northern Ireland, but to the extent it's relied upon, the absence of any express power, we say Roberts in particular is the clearest answer to that.
Well, I see Roberts as giving a power to the board to do what's necessary in order to allow it to undertake its function. Now, Section 17 of the Inquiries Act gives me a power, and one might say that that gives me a power to do whatever's necessary to perform my function.
Yeah.
And so then, in interpreting the breadth of Section 17, we have to understand what function I'm performing in that respect. And just because we can do, or the board can do something as of necessity in order to be able to comply with Article 5, doesn't really necessarily seem to me to tell me that I can appoint a special advocate. It might tell me that I have to make sure the proceedings are fair, but I'm not sure it tells me I have to appoint a special advocate.
But I'm not sure that...
It even tells me I have the power to do so.
Well, except, and this is where we, in one sense, the potentially... The key issue may be the issue I'm going to turn to, which is why do you need to appoint a special advocate on the facts? At this stage, in one sense, my arguments are premised on the assumption that the appointment of a special advocate is needed for fairness in the circumstances of this case, or that it might be needed in the circumstances of some case. Now, certainly we would say it's very easy to conceive of circumstances where it would obviously potentially be needed. I mean, if you were to have, suppose you had a relatively narrow public inquiry, which is not obviously unusual, where an individual's conduct was directly an issue, and that individual couldn't participate in closed proceedings, and closed hearings were highly relevant. Well, in those circumstances, it would be surprising if there wasn't a power, because fairness would point very strongly towards it. And all at this stage, it seems that certainly we adopt, in one sense, and the approach of Counsel to the Inquiry, and submit that the first question is, do you have the power? And our submission is yes, if it's in the particular circumstances, it's a special advocate is required as a matter of fairness. That then leads, which may arguably be the much more difficult question, which is, does fairness require it on a special advocate on the facts? And that I accept that. Roberts doesn't provide the greatest. All Roberts indicates is that a special advocate. What Roberts indicates that's relevant to that is that a special advocate may be of value in terms of testing material enclosed, but it doesn't obviously, in particular, deal with the issue of whether that same function can be performed by Counsel to the Inquiry. Turning then to AHK, AHK is at tab 25 of the authorities, page 524. AHK is probably, again, AHK was again a situation where what was an issue was a PII certificate.
It's a bit complicated by the fact that it was rather disapproved of in the Supreme Court, isn't it?
Well, it was disapproved of. What was I mean, it goes back to the point I made about al-Rawi, which is it was disapproved of to the extent it might be relied upon to indicate there was an implied power to have a closed procedure, because there was some assumption that effectively, potentially, the closed material could be relied on substantively. It doesn't, what the Supreme Court said in my submission doesn't cast doubt on it in terms of what it says about the potential value of a special advocate, in particular in relation to where effectively there is a power to withhold material, in that case for PII purposes.
It maybe doesn't add much to.
It doesn't add a huge amount. I mean, the only thing it does is it does two things. One, again, in our submission, I can jump ahead of it, but what it does again, it's again, and this is the controversial bit in one sense of it. It starts from the assumption that there was an ability to hold some sort of closed procedure. It then held that you could, implied into that, have a special advocate to mitigate the unfairness of that. And similarly, in relation to the test, it focuses on fairness rather than some issue of exceptionality or something along those lines. That's the reason it assists to some extent. The final area, and again, given what you just said, I can probably go through this fairly quickly again, but we did pick it up. We only picked it up in our supplementary note, but we hoped it assist. The other area where the use of special advocates appears to have developed, certainly initially without statutory authority, but appears to continue actually without statutory authority, is in relation to family law, where certainly the English High Court has recognised that in circumstances where material has to be withheld from a parent, the appointment of a special advocate can be necessary to mitigate unfairness. And that, as I say, appears to continue. This may be relevant when looking at the 2016 Act, the Investigatory Powers Act, because it is a provision, it is a relatively common use of special advocates. Not that special advocates are common in any context, but it's certainly happened on a number of occasions, and it isn't expressly addressed in the 2016 Act. Despite the fact that its use developed before the 2016 Act. And the reason why I say it doesn't appear to be addressed is because on the face of it is a context in which there aren't any rules of the nature required by the Justice and Security Act. There aren't any family rules. That was acknowledged by the High Court in the case of R, which is in the authorities bundle at page 893, tab 17, and yet special advocates continue to be used. And so family law may be of this assistance because it may show that the Investigatory Powers Act isn't comprehensive. But again, the structure of it is it starts from the basis that there was a power to withhold the material, and then looks at how unfairness can be mitigated. So what we submit is that all of that case law demonstrates, which we submit is consistent with the scheme of the Inquiries Act, which is that where there is a power to withhold material from a party, a duty and a power to act fairly can then be used to mitigate the obvious unfairness of that, and can, as a result, be used to instruct a special advocate if that is required to ensure fairness. So when looking at whether the power exists on the fact, in principle, in the Inquiries Act, we submit, well, yes, it must do, because there are obvious circumstances in which fairness might require a special advocate because of the nature of the closed procedure. Does it in the circumstances of this case? Well, that's the more difficult question, and that's something that I need to come to. Before doing that, can I just deal, because it sort of links with some issues that sort of link into this issue of the power. The most important of those, possibly, or the most significant of those, is the Investigatory Powers Act. Now, the structure of that is, as you've already been told, sir, that Section 56, which is at page 70 of the bundle, tab 8, prevents evidence being adduced, questions asked, assertions made or disclosure, or, subject to Schedule 3. Those things happening rather in the context of Inquiries Act proceedings in relation essentially to intercept material, but that's subject to Schedule 3. Schedule 3 then sets out a number of exceptions where effectively then there can be questions asked, etc., in relation to intercept material. And there are a number of things to note about Schedule 3. Firstly, it's clear that it's not necessarily comprehensive in the sense that it doesn't cover every circumstance where a special advocate may need to be appointed. On the assumption I'm correct that family proceedings are still not caught by the Justice and Security Act because they don't have the necessary rules, it makes no reference to family proceedings. That's the most obvious circumstance. Secondly, in relation to criminal proceedings, if you go to paragraph 21, of Schedule 3, which is at page 93 of the bundle, you'll see there that there is no reference, as far as I can see. Schedule 21 is essentially the provision that allows for a judge conducting criminal proceedings to, as I understand it, conduct a PII exercise, certainly to consider material caught by Section 56. There's no reference there that certainly I can see to a special advocate, and it's difficult to see how a special advocate fits into Section 21. Now, it would be surprising, given the importance essentially attached to the use of special advocates in appropriate circumstances, it would be surprising if special advocates were no longer permitted in criminal proceedings in appropriate cases where necessary for to ensure a fair trial.
I'm not sure I'm following that, Mr. Southey.
Well, my Lord, the point I'm making is that what is expressly relied upon by the Counsel to the Inquiry is in relation to inquiries, paragraphs 22 and 23, the absence of any reference to special advocates.
Yes. And
it said that's an indication that special that Parliament didn't anticipate the use of special advocates essentially in the inquiry context.
But are you suggesting that paragraph 21 would accommodate the use of a special advocate?
No, I'm not. What I'm saying is that you can't, from this, draw any implications about the context in which special advocates will potentially be used, because paragraph 21 is dealing with the Queen and H situation, and yet it makes no reference.
I don't think it is. I don't think it is. I think it's probably more akin to the situation that existed in Preston. It's a situation in which there may be information known to the security services which is not disclosed to the Crown Prosecutor, is not disclosed to the judge, but which, if it were not brought to the attention of the prosecutor, might result in him advancing a state of affairs which was inaccurate or unfair. And so it's a provision that allows the consequence of intercept material to be brought to the attention of the prosecutor so that he can then take the correct steps. One of those steps might be to abandon a line of examination that he was inclined to pursue. Another might be that he needs to tell the judge so that the judge can force an admission to be made if necessary. And another is to ensure that the prosecutor can consider whether or not it's safe to continue with the proceedings. It's nothing to do with PII. This is never going to result in intercept material being disclosed.
Well, The reason why I was drawing an analogy with the H situation is that what I draw from H is that essentially if a judge becomes aware, I mean, the normal position would be obviously that if a judge becomes aware that the public authorities hold material that is potentially relevant to the criminal prosecution, it would need to be disclosed. Now, this isn't, clearly this envisages that material, the intercept material, partly because it can't be used, being withheld, but it's still, the basic concept in the Queen and H we would submit potentially would apply in the section 21, in the paragraph 21 situation, because there's still a potential need for fairness in the sense of someone making submissions about material that might be of use to the defence and may have relevance to the way in which the conviction is or the prosecution is being conducted.
There's no scope for a special advocate being appointed under paragraph 21.
Well, that's my point, my lord. Is that Schedule 3 in our submission isn't necessarily comprehensive, and it doesn't. There are issues about. My point is that if it would be surprising if through this route the potential need for a special advocate to ensure fairness was now ruled out. That's my point. Similarly, I mean, my lord, as I say, that's why I started from the position, which is actually the more significant omission, is there's no reference at all to family law, despite the importance attached to family law, special advocates in the use of family law. But my lord, the more significant thing, just to summarise, as I say, our submission is that this isn't necessarily a comprehensive list of every circumstance in which special advocates are required. Now, in terms of paragraphs 22 and 23, which I accept are obviously much more important, two things really we would emphasise, I think. Firstly, if you look at paragraph 22, subparagraph 2, the order of the disclosure of intercept material, or the disclosure of material caught by section 56, is only in exceptional circumstances. So the implication of that would appear to be, we would submit, that in many cases closed material can be closed material proceedings, a closed aspect of an inquiry can often be conducted without reference to material that potentially falls within section 56. And that's not surprising. If you think about the facts of this case, for example, quite often it will be, and I accept on the facts of this case this may not be exclusively the case, but it quite often will be important that there was intelligence, not necessarily the source of the intelligence. But in any event, Para 50, the more important submission in our submission, and the reason I make that first point, just before I move on, is because it would be surprising in one sense if something which is only meant to occur in exceptional circumstances, to use the language of the statute, were to drive or were to be the basis upon which it was concluded essentially that there was no power to order a special to appoint rather a special advocate, because special advocates will potentially be of value in a wider range of circumstances. This doesn't say anything about the potential contribution they make to fairness in other circumstances. Secondly, turning then to para 23, which may be in one sense more important because that's the provision that allows for restricted proceedings to take place. Two things to note, really, which are linked about that. Restricted proceedings, for the purposes of para 23, are not necessarily everything caught by section 19. Restricted proceedings obviously has a very specific meaning. It relates to proceedings which a limited number of people only can attend. Those are people who are specified in subparagraph 2.
Well, I suppose restricted proceedings only concern material that's otherwise prohibited by section 56.
That's right, but the restrictions in place, and these are the restrictions that the effect of this, it goes back to the question you asked me this morning, the effect of this is that if there are to be restricted proceedings considering material containing section 56 material, the only people who can attend those proceedings are those who are specified in paragraph 2. We accept that. Subject possibly to any interpretation necessary to comply with the Human Rights Act. And that's the point I was making, really, was that in most restricted proceedings, one can envisage the parties who are likely to attend are likely to be all the state parties, and that's partly because they will have security cleared lawyers, they will have security cleared people handling the material internally. There won't be a security concern about them receiving the material. The definition of restricted proceedings or the definition of who can attend in 23.2 is potentially narrower than that. So one has to be a relevant party or a person representing a relevant party. And a relevant party is defined in subsection 4, or paragraph 4 rather, effectively as being people who have in some way been involved in the intercept material, or the material caught by section 56. So it is not necessarily clear to us, and this may be the difficulty of being an open advocate, one doesn't know how these things operate in practice, but it isn't necessarily clear to us, for example, that material that is provided by MI5, to use that as an example, if it's caught by section 56, would necessarily enable PSNI to hold proceedings conducted in relation to under paragraph 23 subparagraph 2, because they're not PSNI are not necessarily a relevant party. Now, that on the face of it would seem slightly odd and unfair, and the way around that in our submission is that subpara E in our submission is there. It's a catch-all there, and it's there in part because it links back to the structure of the Inquiries Act. You've already seen what you've already heard rather what I've submitted about section 17 rather. We submit section 17 is deliberately in broad terms because it allows flexibility to deal with the range of circumstances that the inquiry faces. It's not. One can't necessarily draw an analogy with the Special Immigration Appeals Commission because the Appeals Commission deals with a very sort of distinct type of case which will proceed in a particular way.
Why would it be unfair if PSNI were not able to attend in relation to a hearing that was canvassing or listening to evidence from MI5?
Well, I don't think I used the language of unfair, but I was saying there was not necessarily any obvious justification for it if they've got appropriately cleared individuals. It might be unfair.
Well, slightly odd and unfair.
If I used unfair, but I was saying it might be unfair. I would say it might be unfair because it might be that the material was relevant to a criticism of someone from PSNI. It wouldn't automatically be unfair, perhaps is a better way of putting it, but it might be unfair. But all of that, if one looks, just to put in context what the answer I've just given, and I was just talking about the flexibility inherent in section 17. If you look at subsection E, or subpara E of para 2, that's expressed in broad terms. Now, the explanation that's relied upon of this against me is it's to cover people like clerks who are and transcribers, and they're potentially necessary. It's to deal with the admin staff. Now, to put that in context, if you go back to paragraph 7, which deals with the Justice and Security Act provisions, there is no reference there to court staff potentially dealing with disclosure, not that I can see. I use that as an example. It's not unique in that, but
that's because of the introductory words, I think. Paragraph 7, in common with the other paragraphs, tells us that section 56 doesn't apply to, in that case, closed material proceedings. So the exemption doesn't apply. The prohibition, rather, doesn't apply. So anybody who's part of those proceedings can be there unless they're excluded by what comes later. But within it, sorry, the reason why I'm not sure that it's necessarily as straightforward in that, in the sense that if you look at subparagraph 3, which is looking at proceedings under the Justice and Security Act, there is then limitations as to who disclosure can take place to. Well, I understand that, but I think the point is that if you're wondering how clerks, assistants and the like all get into other proceedings that are governed by Schedule 3, it seems to me it's because of the opening remarks in each of the paragraphs. It says it doesn't apply in relation to any proceedings in these types of litigation.
Well,
so that seemed to me to mean that the ordinary people concerned in those processes would be present unless, as is the case in most of the paragraphs, it then goes on to tell you who can't be there.
But I mean, that, for example, isn't necessarily universally the case. So para 21, for example, is another example.
But paragraph 1's a very different thing. That's not dealing with any proceedings at all. That's dealing with a particular disclosure that's made privately to the prosecutor. That's not proceedings.
But the more fundamental point that I would make in any event about this is that why should in one sense it links back to the point that my lord was putting to me about Roberts and the statutory framework about doing something that was conducive. The special advocate was found in Roberts to be appointable because there was a general provision allowing for steps to be taken that are conducive. if a special advocate, if someone needs to receive material to ensure fairness, despite the powers in Section 19, it's difficult to see why that isn't needed for the proper functioning. I mean, why draw a distinction? I mean, one way of putting this is why draw a distinction between a clerk who basically performs an administrative task, who probably one could avoid if need be, and someone who is appointed because without their appointment there won't be fairness. I mean, if Roberts says you can that the words, which it does, conducive to the functioning, that may not be the exact wording, but it's something along those lines, that a special advocate can be conducive to the functioning, why can't a special advocate be necessary for the proper functioning if that's necessary to ensure fairness? Because the proper functioning is fair functioning. Two other points that I should make about this provision. Firstly, the Secretary of State for Northern Ireland submissions at paragraph 17 make reference to the provisions, I think, that were found in the Regulation of Investigatory Powers Act, if I remember rightly, at the time the Inquiries Act was enacted, not something Counsel for the Inquiry has particularly focused on. Their submission essentially is that when the Inquiries Act itself was enacted, which may be of some relevance because obviously we say subsequent legislation carries limited weight, when the Inquiries Act was enacted, the provisions essentially, the equivalent provisions only provided for disclosure to the inquiry panel alone. That, in our submission, in one sense, doesn't undermine the arguments about special advocates. It demonstrates, really, probably at the time when the Inquiries Act was enacted, there may not have been a proper anticipation of quite how many people might need to consider sensitive material. For example, Counsel for the Inquiry wasn't, at that stage, apparently caught by the relevant provisions. That explains why, I mean, what one can get if what one potentially sees if one looks at the statutory history of this is a recognition that actually, because of the sensitivity, the need to handle sensitive material, a wider range of people potentially needed to consider the sensitive material to ensure that the inquiry was effective. That's the basis what we would submit for the addition of subparagraph E, the paragraph you've just seen, about disclosure to people performing functions necessary for proper functioning. And as I say, we submit that broad terms links back to Section 17, because Section 17's in broad terms, it's deliberately there to give flexibility to allow the inquiry to do what's necessary, and that is now reflected in the 2016 Act. There is this catch-all provision that allows, that is consistent, we would say, with that. The second point we make, we reference, and I think we're not alone in this, I think the core participants represented by Mr. Burney make reference to it as well. We reference Benyon and what is said about later legislation. you'll see that it's in the authorities bundle at tab 58, page 2053. It sets, perhaps unsurprisingly, a high threshold we would submit in essence before very much assistance can be drawn from later legislation. In particular, it makes it clear that although later legislation can be relied on in relation to ambiguity, the test for ambiguity is a high one. It's on the second page at the top of 2054. We certainly don't accept that test is met. The clear, and we say it's not met because the clear expression of the requirement for fairness implies that a special advocate can be instructed if that is required, and nothing in 2016 Act expressly repeals or amends that. And it would have been easy, had Parliament intended that it wanted to make clear there was no power to appoint a special advocate, it would have been easy to say that expressly. It's a slightly odd way of doing it. So we submit the 2016 Act ultimately doesn't, the 2016 Act might cause an issue in terms of what the special advocates can do, but it ultimately doesn't really assist in interpreting this primary issue, which is what are the powers of the inquiry in relation to the appointment of a special advocate. I'm conscious of the time. I need to come on to the inquiry rules and then go on to Article 3 and then the arguments, Article 2 and the arguments about the appointment and facts, but I'm conscious that we haven't had a break.
Yes, so we'll break at this stage maybe for 10 minutes or so. Thank you. So when you're ready, Mr. Southey.
Thank you, sir. When we broke, I'd almost finished, and I thought I'd had finished, but then I look at my notes, there's one other thing I think I need to just touch on. Domestic law, the Inquiries Act, and the extent to which that authorises the appointment of a special advocate. The one thing I hadn't addressed, which I realise I ought to have addressed as a matter of domestic law, is the inquiries rule and the rules. And obviously the inquiries rules, on the face of them, make no reference to special advocates. They deal with, they provide for questioning by recognised legal representatives, but don't address the position of a special advocate. Our submission in relation to that, in one sense, is a simple one. They are secondary legislation. They have to be interpreted consistently with the Inquiries Act, and in particular the duty in the Inquiries Act to act fairly. If they authorised and express, if they authorised or required perhaps a provision of, if they required rather a procedure that was unfair, that would mean they were ultra vires in our submission. And in the light of all of that, and that's consistent, we would submit with Section 17, they can't be regarded as a comprehensive code. There is plenty of case law. We cite one example of it, a recent example from the English Court of Appeal. There's plenty of case law that makes it clear that that fairness, common law fairness, can supplement effectively rules. And in this context, that is obviously required by the provisions of Section 17. Section 17, if it requires a particular step, because a particular step is necessary to ensure fairness, the fact it's not addressed in the rules can't prevent that step being taken. Fairness ultimately trumps, subject to any other provision of the Act. Then can I turn to Article 2? We accept, otherwise Section 19 would be incompatible potentially with Article 2, that Article 2 doesn't necessarily always require public hearings involving next of kin. However, that doesn't mean there is never a right in particular to family involvement. And for these purposes, because we're focusing on special advocates, I want to focus in particular on the involvement of next of kin, because inherent in the idea of a special advocate is that the proceedings won't be in public. We're not challenging that. What we are challenging is the what we are arguing about rather is the use of special advocate. Now, can I take you to Amin, which has already been referenced? If you go to tab 18, which is at page 244 of the, and the relevant page rather, it's at 244 of the PDF, you'll see Lord Bingham's judgment. And Lord Bingham had to, because there'd been a range of investigations already, consider the investigations that have been conducted in order to determine whether they were compliant with Article 2. And Lord Bingham ran through those investigations, really paragraphs 34 onwards, and you'll see he firstly looked at the police investigation, accepted, of course, that had to be conducted in private without participation of the family, no criticisms of that. Then looked at the trial, but to some extent discounted it on the basis that it didn't really consider the issues in the case. Then went on to two other investigations. The first was one which was conducted by someone called Mr. Butt. That you'll see, if it's although it's described at para 36, the background to it is set out at para 8 onwards, and it was essentially an internal investigation under the leadership of a former a serving prison governor, a man called Ted Butt, basically. And that, it wasn't criticised, but was noted to essentially have been conducted in private. You see that at the bottom of the paragraph, four lines up from the bottom, and have been a process which the family were unable to play any effective role in relation to. There was then a CRE report, I think that's Counsel for Racial Equality, if my memory serves me rightly, which was also noted to bring additional facts to light. But again, it was noted significantly to be in private, and so not an effective part. And so not something rather also that the family were able to play an effective part in. And that's the context in which there was found to be non-compliance, in part because there were further questions that the family would want to participate in. So one can see there that while it's absolutely correct that part of the investigation could be conducted in private without family investigation, and that's perhaps the most important part, that it wasn't acceptable for all of the stages to be conducted in private. So the question is, how do you assess when family involvement's adequate? And the test in our submission is clear. It's set out in AMIN, but it's been repeated in a number of cases. If you go back to page 236, paragraph 20, subparagraph 9, the test identified from Jordan is that the next of kin must be involved to the extent needed to safeguard their interests. And that's important.
Necessary, needed.
Sorry, yes, sorry. And it's also obviously legitimate interests. Sorry, I should emphasise that as well. But that's important because I'm going to come in later on to the role the special advocate can take. But we submit that safeguarding of interests, in summary, is not simply about, for example, questioning witnesses. It is also, for example, about being able to assess whether, for example, there's an error of law in relation to what happens enclosed, in relation to a key part of the proceedings. And again, given that we're at the moment primarily looking at whether there is a power to appoint a special advocate, suppose, and this case may be, this inquiry may be close to that, suppose that all the key material about state failings were enclosed. So the next of kin had no direct involvement in the closed proceedings. The next of kin could pass questions, raise issues with counsel to the inquiry, but wouldn't, for example, know whether anything had happened enclosed that amounted to an error of law, wouldn't know whether or not, for example, there was evidential basis for the findings that are reached enclosed. It's difficult, if that were the case, to see how the inquiry was compliant with Article 2. And so looking at the issue of power, firstly, in our submission, it is likely that there is a power because it's, again, easy to conceive of circumstances where without a special advocate, essentially the next of kin won't be able to safeguard their legitimate interests. Now, The state parties cite, because it's our submission, essentially there isn't anything directly on case law, and I'm going to come to two things that may provide assistance. The state parties cite two authorities which they say support their position in relation to it, in relation to the instruction of special advocates. The first is Ramsar High. Ramsar High is also in the bundle of authorities at page 415, tab 21. And the issue in Ramsar High, which is the context of the paragraph that's been cited, was whether the proceedings and the decision of the Court of Appeal should have been public. And you see that at para 351. And the passage that's been relied upon is para 353, where it said Article 2 does not go as far as to require all proceedings following an inquiry into a violent death to be public. That's, in our submission, not dealing with the issue of participation, which is the issue that we're highlighting on. And you see that because if you go to 354, it's made clear that the applicants, and you see this, it's about 4 lines into 354, the applicants were enabled to participate effectively in the Court of Appeal hearing. So it doesn't, it's one of the reasons why we say that there's nothing directly on point. It simply doesn't touch on this because it's not concerned with next of kin involvement and how that is facilitated. Turning then to JL, or L, which is the Queen on the application of JL versus the Justice Secretary, which is the other authority relied upon. If you go to page 5, tab 24, page 508, passage of Lord Roger in the House of Lords, passage of judgment of Lord Roger in the House of Lords.
Sorry, what paragraph number did you say?
80.
80?
Yeah. Lord Roger says an investigator, an independent investigator, may well be effective, even though he's not conducting his investigation in public. Again, depends on the particular circumstance. So it's not, that's again not saying anything about family participation, the next of kin rights. And indeed, he bases his judgment on para 353 of Ramsar High, which you've just seen. One thing I would emphasise, which is one of the other reasons for going to this, because it's something I'm going to come to in a moment about Article 2, is he cites a judgment Angelova in Bulgaria, as Lord Roger cites Angelova in Bulgaria first. And what that makes clear, and that's something that I'll come back to in a moment, is one matter that is particularly important in terms of public scrutiny.
Sorry, Mr. Southey, just a minute.
Yeah.
Is your submission here that Lord Roger is simply talking about the necessity to hear an investigation in public as distinct from commenting upon the involvement of the family?
Yes. Because he's citing, if you look at Ramsar, he's citing Ramsar, and Ramsar was expressly a case where there was no issue about about family involvement.
But what if you look at paragraph 82, he says the Grand Chamber has made no attempt to specify types of cases in which a public hearing will be needed. The House should follow that example. But it's worth stressing that whatever the steps the investigator takes from the time of his appointment till he finishes, they're all part of the single independent investigation required by Article 2. That investigation may stop once the initial material is assembled. Alternatively, it may continue with witnesses being heard in private or in public, some in private and some in public, depending on what's needed for an effective investigation. So he's talking about hearing in private.
But he's not. But if you think about Ramsar, Ramsar was a case where the criticism was that the Court of Appeal had heard the case in private. That was held to be unobjectionable, in part because the family had still been able to participate. I took you to the paragraph that made that clear. So there is a distinction drawn in the case law between hearing something in public and family participation. And the family, but nothing in the case law suggests that that basic requirement, the family must be involved to the extent necessary to safeguard their legitimate interests. I think I've quoted that correctly. That test is in any way compromised, my lord. And that's, if you think about Amin, I mean, that doesn't mean that you've got to look at legitimate interests. So, police investigation, they probably don't have any legitimate interest in because it's in an early investigative stage. It's gathering evidence potentially for prosecution. This context, obviously, they do have legitimate interest. That's why they're court participants.
Well, I'm maybe just not following this. You started by telling me that you accept that Article 2 could encompass closed hearings where where there was, well, maybe need to check. Did you tell me that you accept that Article 2 could be complied with in circumstances where there's a closed hearing and the next of kin are not involved?
Well, we accept this. We accept that there can be a closed hearing. We accept that the next of kin can be excluded, providing steps are put in place to ensure that they are able to safeguard their legitimate interests.
And that might include a special advocate, or it might not?
It wouldn't necessarily, I mean, it may depend to some extent, for example, on what is being considered enclosed, because it's a very minor issue, so they don't have any real significant legitimate interest. But it may include a special advocate. It may, and one of the reasons for that, and I've touched upon this and I'll come back to it, is because unless you have a special advocate present, if key findings are being made, you don't have anyone effectively independent determining whether there's been any error of law in the approach to that fact finding. And that's an important aspect. And one of the functions that we identify, and it's one of the reasons, and I'll come back to this, because I will go through the functions we submit can be performed, but it's a particularly important one. One of the reasons why a special advocate is potentially important is that a special advocate can identify whether or not there's been any error made in closed.
Well, I can read my notes a bit better now. You started off by telling me that you accept that Article 2 doesn't necessarily always require a public hearing involving the next of kin.
Yes.
Now, if that's a starting point as a matter of principle, what is it we're taking from Ramsar?
Well, what I'm taking from our starting point was just to add to that, because that's why I started from Amin. The key point is that the next of kin have to be involved to the extent necessary to protect their legitimate interests. The citation of Ramsar and JL in our submission simply don't assist. They're not on point, because all they're focused on is whether or not proceedings need to be held in public. And that's not really the issue here. The issue here is the protection of legitimate interests. And that is not what was being considered in Ramsar or JL. And so I'm just effectively dealing with an argument that is put against me, saying you can't really get anything of real assistance from Ramsar and JL, because they don't undermine in any way that basic submission, which is, or that basic obligation, which is how do you ensure that the next of kin's legitimate interests are safeguarded. Can I just remind, my Lord, I can't remember if I just emphasised this when we were looking at JL before we go away from it, so I don't need to come back to it. I think I did emphasise the importance attached to maintaining public confidence in terms of any procedure. My Lord, given what I've already said, that firstly, in our submission, the issue is not that there is some absolute rule that the family have to be present during every stage of the procedure, but stages of the procedure can require them to be given an opportunity to protect their legitimate interests, or a mechanism rather to protect their legitimate interests. The question then arises in our submission, how do you do that? And as I say, there's no authority directly on point. But we submit that an analogy can be drawn in those circumstances with the Article 6 case law. And the reason for that is not because the rights are the same. They're not. Obviously, the right under Article 6 is the right to a fair trial. But the reason for that is that in the context of Article 6, where security information perhaps has more commonly been raised as an issue, what the European Court has recognised is that what the state can do is take steps that ensure essentially that although the interests of the state are protected, there are, as far as possible, adequate safeguards in place to ensure, as far as possible, adversarial and equality, adversarial proceedings and equality of arms. And the authority we rely on in relation to that is Regner, which is at page 936 of the authorities, tab 34. Now, I recognise these aren't adversarial proceedings, but equality of arms is important because clearly what's anticipated during a closed procedure is that state parties, a number of state parties, will be present for much of them because they will have, there won't be any basis for excluding them under Section 19. They will have the necessary security clearance, etc. And so there is potentially an inequality of arms. And what Regner is authority for, essentially, is recognising that there can be safeguards put in place. That's what the basis upon which the European Court has endorsed the use of special advocates, as we make clear in our application. So what we submit, that what we draw from this is that while it can be legitimate to protect the interests of the state, as far as possible, the interests of the individual must then be still safeguarded. That's the language of the European Court. The other point that we make as being particularly important in this context, in terms of sort of assessing whether there's been compliance with Article 2, is public confidence. I've already drawn attention to what was said in JL. In Amin itself, it's page 235, tab 18, paragraph 20, subparagraph 2. It was recognised that part of the reason for holding an investigation was the need for public confidence in the administration of justice. And one of the ways, and we submit, that you assess essentially whether family participation is adequate or has been that necessary to safeguard legitimate interest, to use more accurately the language of the European Court of Human Rights. One of the ways you assess that in our submission is by assessing effectively whether it is a system that would generate public confidence on an objective basis. And of course, all of that fits with the statutory scheme of the Inquiries Act, which is about finding a solution, essentially, or finding conducting an investigation into something that is a matter of public concern. So we do submit public confidence is a guide, effectively, to whether family participation has been adequate. If it's a system that ought to leave, on an objective basis, effectively the public satisfied with the outcome, then that would tend to indicate Article 2 had been complied with. If the extent of family involvement, rather, is not such to address public confidence, or not such as to give rise to public confidence, then there may be an issue in terms of Article 2. So ultimately, what our submission is in relation to Article 2 is that the test that you should be considering, and the way in which you can assess whether there's been compliance with Article 2, is to look at whether the families, next of kin, have been adequately able to safeguard their legitimate interests in the proceedings, and whether the mechanisms they've been able to safeguard their their legitimate interests is one that will have public confidence. I'll come on to why we say a special advocate is necessary for those purposes in a moment, but that's the test we submit would apply. Now, there have been some fairly extensive submissions, essentially, about interpreting legislation compatibly with Article 2. We've slightly struggled to see why that is an issue. Should you accept, in light of my submission on the facts, that a special advocate is required in order to ensure compliance with Article 2, then in our submission, it's pretty obvious how a compatibility can be achieved. Your basic power to ensure fairness must include a power to ensure that the procedure is one that complies with Article 2. It's difficult to see how there is a problem with finding a power to comply with Article 2 should Article 2 require the appointment of a special advocate.
Given the way that you've just suggested the formulation of that test as to whether Article 2 has been complied with, I think I would find it helpful if you could assist me with a couple of other things.
Yeah.
You drifted into Article 6, and I understand the point that you were making there, although just how relevant cases in relation to Article 6 are may be a matter for debate. And in doing, in touching on Article 6, you also touch on the concept of equality of arms.
Yes.
And that leads me to recognise that in a number of places in your written submissions and today in your oral submissions, you refer to the parties. Now, who do you consider the parties to be?
Sorry, well, when I was talking about the parties, I was in one sense using a shorthand for the core participants. I think generally that's how I was using it. It may have been also I was referring at times, because there are obviously state parties who are identified as core participants. But certainly that's, I think I was using it.
You've also talked about one party not being put at a disadvantage over another. I mean, these concepts sound rather adversarial.
Well, my Lord, there is, and it's why it took you to a moment ago, or not a moment ago, this morning, to the Glasgow Health Board case. One of the sort of, in one sense, difficult concepts that potentially arises from the way in which public inquiries have developed is that although the proceedings are described properly as inquisitorial in the sense that what certainly I would submit that means in this context, because this reflects the structure of the Inquiries Act. They're inquisitorial in the sense that you, sir, have a duty to get to the truth of the matter in simple terms.
But it's a bit more than that, because it encompasses the question of what the function of the family court participants is as well. And that's something that plays into the submissions that you've been making. Now, the function of the court participant next of kin members isn't defined anywhere, but the consultation paper which the government introduced in 2004 on effective inquiries touched on this at paragraph 90, in which they said that the function of the next of kin would be primarily to assist the inquiry in establishing the facts, whatever hopes they may have about the outcome. Now, do you agree that that's an appropriate description of the function of the court participant?
I'd put it a little bit stronger than that in one sense, and what I mean by that is that the legitimate interest of the primary interest of a family court participant is that they have...
Well, I'm asking about the function, not the interest, because the interests might be very different. That's the point that the consultation paper was making, that they have a function, whatever hope they have about the outcome.
Well, but their function to some extent, but the reason I was talking about I would submit the two issues of functions and interests are to some extent overlapping, and that's for this reason. In terms of, and I'm trying to use some neutral language rather than get too wrapped up in functions and interests, what they hope for in terms of an outcome is an outcome that, whatever it is, they can have confidence in as being a reliable one. In light of that, their function in our submission is to potentially to play a role, essentially, which is intended to ensure reliability by, for example, challenging evidence, by making submissions on law, by at times challenging the inquiry if they think the inquiry is doing something that is likely to undermine their confidence in the outcome. All of those are legitimate functions because they're aimed at getting to that conclusion that they seek, which is one they have confidence in. So that's what that's what we would say their role is. That, going back to use the language of the Article 2 case law, their legitimate interests are ones. Their legitimate interest is ensuring that they come to a conclusion, that the inquiry comes to a conclusion they have confidence in. So that Lord, I haven't taken you to the passage of Emin that you will well know, which says, what is it that a next of kin achieves through this process. And you'll remember, I'm sure, it talks about how they have satisfaction in knowing lessons are learned, etc., etc. And that's that's what their function is. Their function is to ensure that they advance arguments, advance evidence, challenge evidence in a manner that leads them actually with confidence that the findings reached are such that lessons will be learnt, that people will be held to account.
Well, all of that might sound a little difficult to square with Rule 10, because it all sounds as though there's a particular set of rights, interests, and positions to advance, which doesn't sit terribly squarely with Rule 10, which determines that essentially it's counsel to the inquiry who conducts the proceedings, subject to the opportunity to make requests, to ask questions, and the like. But that also fits in with something else I was going to ask you about, which is you've often mentioned that one of the functions of the court participant and the special advocate would be to properly test the evidence. I did notice in the Associated Newspapers case that Lord Justice Leveson identified testing of the evidence as being the function of counsel to the inquiry. Is that something you'd agree with or disagree with?
Well, counsel to the inquiry certainly is what might describe as the lead in doing that. But clearly, inquiries, as a matter of practice, for good reason, recognise there are circumstances in which it's appropriate to allow questions to be asked by family members. Manchester being an example of that. For example, there was fairly extensive questioning by family.
My impression is that varies from inquiry to inquiry.
It does, but that may also reflect, for example, the extent to which there's Article 2 rights involved, etc. Because of those, it depends on the circumstances of the case. But all of that demonstrates that the inquiry process certainly has the flexibility to enable the functions that I've just described to be performed by family members, and that's again, it's if you go back to the fact that we're in Article 2 territory, we would submit in getting to a place where the ultimate outcome is one that the public, the family members, everyone can have confidence in. That is a legitimate interest, to use the language of Article 2, and they must be involved to use the article language, and the family must be involved to the extent necessary to safeguard that.
I don't doubt that. It's the question of just how that's achieved, and from your presentation, it's all encompassed in this role that you identify for the court participant and the special advocate, which sounds very similar to the role that a litigator would have in contested proceedings. I mean, just for example, in Queen and Ale again, one of the other things, you've mentioned Lord Roger's contribution a few times, one of the other things he said was that the relatives might be able to suggest lines of inquiry, but being independent, the investigator is free to reject the suggestions if he considers the inquiries would not be useful. Now, that, rather than viewing matters through the lens of what a core participant might or might not want to explore, is the correct approach to take an inquiry, is it not?
Well, yeah, but that's not necessarily inconsistent with the with the AMIN and the submissions I've already made about safeguarding, being involved to the extent necessary to safeguard one's legitimate interests. I mean, if a core participant makes a submission to an inquiry chair that they want to ask questions about X, they are safeguarding their interest by raising the topic, having that considered by the inquiry. Now, if the inquiry comes back and says, we don't think that's going to further the investigation, we can't see how that's going to be of assistance, it seems to us that's going down a rabbit hole that won't be of value, then that's a legitimate decision. Equally, of course, though, that if the inquiry comes back and says, I'm using something that's deliberately sort of off the wall, but to use it as an example, if the inquiry were to come back and say, but you're ginger-headed, we don't like ginger-headed people making submissions, then clearly that would be a breach of article, because it would be failing to investigate a matter on an arbitrary basis. Now, so it's, I mean, Lord Roger's remarks can't be read as meaning effectively the investigator has complete discretion to make arbitrary decisions in terms. They've got to be. There are a number of principles, and
I'm sure he wouldn't.
Yeah.
But they do point away from the sort of adversarial presentation of somebody who has a case to present, who has interests to advance, and who has a position to present. It points away from that.
Well, except I'm not suggesting. The major distinction in my submission between the role I'm suggesting and the role of a litigant is, if someone's a litigant in say in a normal civil claim, they have a distinct outcome they want. They want to establish that they were assaulted, or they want to establish that that someone was negligent to them, and so they are trying to build a case. What one hope, what certainly the core participants I represent are seeking to do is not that. What they're seeking to do is make sure the evidence is properly tested, so that the findings are ones that they can have confidence in. If there's a line of inquiry...
This all suggests a sort of supervisory role, and it's consistent with what you've identified a special advocate could do. Ensure the inquiry adheres to its duty to act with fairness, ensure the information received is properly tested, and ensure the applicants are not left with a sense of injustice. But all of these things are the function of the inquiry as well. But now, there's one thing I wanted to ask you to comment on, because I suspect you don't agree with it, so it's best it's flushed out. When the House of Commons Public Administration Select Committee issued its first report in the session 2004-2005, called Government by Inquiry, it considered and gave advice upon the bill, and it set out its conclusions at page 82. And the fourth conclusion was this, and it's talking about circumstances in which evidence may be led in private. We recognise that circumstances may sometimes require inquiries to hold all or part of their proceedings in private. Ensuring the independence of the inquiry will serve to reinforce trust in such circumstances. So trust in the independence of the inquiry the chair and the council appears to have been seen by the select committee as the method of ensuring fairness where private hearings were necessary. Now you would say that's not adequate, I think.
It's not necessarily adequate. And the one primary, well, there's at least two, and I was going to come back to this, but I'll deal with it now. If you think, to put this in context, there will obviously be a significant number of open hearings. During those open hearings, all the course participants will potentially be represented, and they will be represented despite the fact that the inquiry will be independent and will have its own counsel. In part, we would submit, because for two reasons. The first is that however good an inquiry is, however diligent an inquiry team are, inquiry chair are, nobody will necessarily spot every point that needs to be taken. And representation allows, at the very least, lines of inquiry to be suggested by people who understand the core participant they represent, what their instructions are. It allows lines of inquiry to be advanced. And secondly, linked to that, the best inquiry in the world has the capacity to make errors. And one thing that potentially builds confidence in an inquiry outcome is if a range of parties are represented and their legal representatives ultimately say, no grounds for challenge here. And those points explain why, in our submission, there is an express recognition within the rules of participation by core participants and representation of core participants. And if effectively fairness could always be achieved by the chair and the and counsel to the inquiry and the rest of the legal team for the inquiry acting with diligence, the normal position, which is core participants can participate and they can participate with representation, simply would be unnecessary. It would be
well, I'm not sure about that, because in closed hearings, the inquiry will be dealing with material that the participants cannot comment on. And all the more that's likely to be the case in this sort of inquiry than it might be in some. And so if there isn't an opportunity for the core participants to feed information because they're not aware of the content of the closed material, I'm not sure how that point arises.
Well, 2 points I'd make in relation to that. Firstly, just in terms of how it arises, if you have a special advocate, which is, if you have a special advocate who has experience of closed material, which they are likely to have, who understands what the broad concerns of the core participant they represent or they're appointed to assist are, there will potentially be arguments that they can advance in relation to that material, which won't necessarily be obvious.
But a counsel to inquiry could do exactly that, surely.
Well,
because if there are broad areas of interest, then they can be communicated to counsel to the inquiry. My difficulty is understanding how, when you're dealing with closed material to do with intelligence or the like, how information held by the family participants could be fed into that in order to test it?
It's not so much, I mean, it may or may not be that there's information that they can feed into to test it. It's more that testing can, if there are particular areas of concern, the special advocates can ensure that the testing takes account of that. I mean,
isn't that just what I said, that the Counsel to the Inquiry could do that?
Well,
there has to be an advantage, I'm sure.
Well, the advantage is that a special advocate will have had an opportunity to take privileged instructions.
But what could be privileged in the context of an inquiry where we're all working together to try and ascertain the truth?
Well,
what privileged information can your clients have about how the bombing took place, or about what the intelligence services could or couldn't have done?
It's not so much what privileged information they have about how the bombing took place. It's privileged. It's instructions that are privileged, in the sense of people having confidence. That obviously the whole basis of privilege is that people have greater confidence in someone that they can talk to in private, discuss what their concerns are, and then advance those.
Well, that's certainly what happens in contested litigation, but that brings us back to the question of what function we're all performing here. But it's obvious, isn't it, from the very fact of the Litvinenko inquiry, for example, and the Manchester Arena inquiry, that Article 2 compliant inquiries can take place in circumstances where substantial amounts of evidence are led in closed hearings, from which the next of kin are excluded, and in which special advocates do not participate.
But, well, the first thing I'd say is I wouldn't necessarily concede that and I haven't conceded, I think, at any stage, that Manchester and or Litvinenko were Article 2 compliant. That's not, I wasn't a party to them. I wouldn't necessarily concede that. But secondly, more...
Well, that's a bit difficult, Mr. Southey.
Well,
but there is also... There is at least one case, I think, where the European Court has at least considered the operation of the 2005 Act and done so in the context of how the 2005 Act operates restricted proceedings. Is there not?
I'm not aware of the case my Lord is referring to.
Well, you surprise me.
Okay, well that may be my fault.
It's Carter against Russia, which was the Litvinenko case taken to the European Court of Human Rights. Mr. and Mrs. Litvinenko, when they became naturalised British citizens, changed their names to Carter. But for circumstances that are not known to me, the inquiry was conducted under their original names. But Mrs. Carter subsequently took a case to the European Court of Human Rights in which she claimed that the Russian state were in breach of the substantive limb of Article 2. In other words, that it was unlawfully responsible for the killing of her husband. And secondly, that the Russian state was in breach of its procedural obligation in terms of Article 2 to carry out an effective investigation into her husband's death. And the court upheld both of those claims. But in doing so, it relied on the findings of the inquiry.
Yes, sorry.
And as we know, of course, that was conducted without the benefit of a special advocate. And a number of things are interesting about the case. The first, I suppose, somewhat peripheral, is that Mrs. Carter was represented by Sir Keir Starmer and Ben Emerson.
Yes.
One might say that you couldn't get a better combination of human rights lawyers, present company accepted. But when they appeared before the European Court of Human Rights, the Russian state objected to the court taking account of the inquiry's findings, and Mrs. Litvinenko's legal team submitted that nothing in the Russian government's claims cast any doubt on the evidence which had been led in the inquiry or on any procedural process that had led to the chairman's findings. So in other words, by the time of the hearing before the European Court, Mrs. Litvinenko and her team were defending and relying upon the closed procedures which had been adopted by Sir Robert. And the court then went on and looked at what had happened. They noted that closed hearings had been heard over a number of days. They noted that during the course of those hearings, Sir Robert had heard evidence about the nature and the extent of the relationship between the Litvinenkos and the British Security Service and the intelligence agencies, and the question of whether the Russian state was responsible for his death. It noted the various findings which had been made by the inquiry, which were that Mr. Litvinenko had been fatally poisoned, that he had been poisoned by Mr. Lugovoy and Mr. Kovtun, and that when they did so, they were acting under the direction of the SPF. And the court, having looked at the findings, decided that the principle it would apply in determining whether or not to rely on those was this, and it's at paragraph 98. The court's reliance on evidence obtained as a result of a domestic investigation and on facts established within domestic proceedings has depended on the quality of the domestic investigative process and the thoroughness and consistency of the proceedings in question. And in order to apply that test to the findings made by Sir Robert, it noted a number of different things. It noted first that inquiries are not adversarial in nature, they're inquisitorial and aimed at establishing the truth. It's paragraph 79. It noted that inquiries are carried out by a chairman. It noted the procedure and conduct are to be such as the chairman may direct. It noted the chairman must take steps such as are reasonable to secure members of the public are able to attend and to see and hear a simultaneous transmission of proceedings. It noted that there was an opportunity pursuant to section 19 to issue a restriction order or a restriction notice to restrict public access and the disclosure of evidence where there's a risk to national security or where a person has obtained information on condition of confidentiality. It then noted the various factors of relevance within the rules. And once it had done all of that, it decided that it could and should rely on the findings made by Sir Robert. And it explained why at paragraph 100 to 104. Firstly, that a High Court judge with many years' experience was appointed as the chair. Secondly, he was assisted by a team of lawyers, including counsel to the inquiry, that their function was to elicit the facts without fear or favour towards any party or any particular line of inquiry, and to examine all the evidence from an objective and independent standpoint. Next, it noted that in addition to being independent, the inquiry satisfied the requirements of transparency and accountability. The open evidence was received and the witnesses were heard in public hearings. Members of the public and press had unrestricted access to the hearings. Next, it noted that decisions taken by the chairman were susceptible to judicial review. And next, it noted that all interested parties were eligible to apply for core participant status, and many did. And then it said at paragraph 108, it's true that neither the parties nor the court have had access to the closed evidence, as this material has been in the exclusive possession of the United Kingdom government. However, in cases where the court has not had sight of national security material on which decisions restricting human rights are based, it has instead scrutinised the national decision-making procedure to ensure that it incorporated adequate safeguards to protect the interest of the persons concerned. The court therefore takes note of the fact that the closed evidence procedure was set out in detail in their inquiry report, and the nature of the closed material was described, albeit in broad terms. The chairman, counsel and the solicitor to the inquiry and the legal team for the Home Secretary were present at the closed hearings. Counsel could make submissions regarding documentary evidence, and witnesses giving oral evidence could be questioned by the chairman and counsel. Although material subject to a restriction notice could not be referred to in the public hearings and had to be redacted from the report prior to its publication, the restriction notices were themselves public documents, which were published both on the inquiry website and also as appendices to the report. So on the basis of that analysis, the court took account of the Inquiries Act procedure and concluded two things. First, at paragraph 108, that to the extent possible under the circumstances, the taking and use of closed evidence was attended with appropriate safeguards. And second, at 110, it had no reason to doubt the quality of the domestic investigative process or the independence, fairness, and transparency of the proceedings. And so I wondered whether it might be possible to take two things from that case. First, that the European Court of Human Rights declared a robust endorsement of a process which included substantial closed evidence and hearings conducted in the absence of non-state court participants and without the appointment of special advocates. And second, that an endorsement of that nature would be indicative of the fact that an acceptance of a process of that nature can be considered fair and compliant with the Article 2 investigative duty. So it occurred to me that there might well be some value in that case.
Well, can I apologise? I think it's fair to say, having my immediate reaction being I couldn't remember, I do actually have some memory of that. I do remember having looked at it. Our view, I think, was that the nature of the complaint, which was obviously against Russia, where what was being sought to do was place reliance on it, and in particular the fact that there was no complaint about the whether or not the UK had complied with the standard that I highlighted from Amin, meant that Carter and Russia was of limited of any significance, which may be consistent with the fact that I don't think it's referred to in anyone's submissions in relation to that. That may be an error, but the fact of the matter is, it's still the circumstance, the analogous, the issues that arise in this case would have arisen had the Carters brought their proceedings against the United Kingdom, saying that the procedure didn't allow wasn't one that allowed for the adequate safeguarding of their interests. If, for example, they had been unhappy with the result of the Litvinenko. And what I wanted to, I hadn't finished in one sense what I was saying about the.
Do you mean the Article 2 compliance would be determined as to whether or not the parties were satisfied with the outcome?
No. What I'm saying is that's the basis upon which a complaint would be brought, because that's how the particular issue would arise, rather. But what I was going to say was, which it wasn't touched on in that case. So you were putting to me about the role of counsel to the inquiry, and I was explaining what I thought they could potentially do in close, or one of the areas. Can I emphasise, though, because I didn't actually get on to the key role, because the more we've prepared for this, the more it certainly seemed to us that this is the key role in terms of public confidence, and that's why the point I just made is of relevance. I don't accept what you put to me about in terms of testing evidence in relation to clothes, the families have nothing to add, or nothing to add that couldn't be put through counsel to the inquiry.
Well, I don't know if they do. I'm asking you that. What that's my question, is what could they add into that?
Well, I in one sense, I've said, what they will have particular concerns. They've already expressed concerns. They've expressed concerns in the judicial review. They've expressed concerns about areas such as the extent to which intelligence sources were providing material that was potentially relevant. But I accept they have no direct knowledge of that other than what is in open. But the role of the special advocate in those circumstances is to ensure that their concerns are properly advanced. But the second point I was going to make, which is in one sense more important, and it is important I make this clear, which is let's assume that. Because I was drawing an analogy with what happens in open. Let's assume that in closed, because of their knowledge of the circumstances, the court participants can add very little in terms of questioning of the closed witnesses. There is a second, but actually particularly important sort of aspect of the procedure that is important partly because of the importance of public confidence, which I described, which is, let's assume the court participants have no questions that they want to ask of a closed witness, no questions they could properly ask of a closed witness, maybe no submissions they can make about the findings. At the same time, when findings are made, obviously they need to be lawful findings. They need to be properly based on the evidence. They need to be rational. They need to properly take account of all relevant evidence. And they are in principle challengeable in judicial review proceedings. And the Inquiries Act recognises that they are challengeable in judicial review proceedings by including provisions about judicial review. The second important role that open advocates play, which is not going to be played, can't be played by counsel to the inquiry in our submission, is essentially advising as to whether there are grounds of challenge, whether the findings are reliable. And that role in our submission is really important. In what happens in open includes, at the end of the day, the representatives of court participants saying to their clients either, and hopefully this is the case generally, being in a position to say, we don't think there's anything to challenge in these findings. These are perfectly proper findings. These were based on the evidence. These were findings that the inquiry was entitled to reach. They were proper assessments of the evidence. Nothing to see here. And that the part of the problem is, and it's why I drew attention to equality of arms and things like that, is that if you hear closed evidence, which is relevant, for example, to alleged failings by a state body, if the state body will probably be present because there'll be no justification for excluding them, if they are unhappy with those findings, they will be in a position where they can say, we want to bring judicial review proceedings if they are of the opinion that there is a legal error in them. If the court participants I represent are excluded, they will not understand the legal basis, excluded in the sense of not having a special advocate. They won't understand the evidential basis, that's inevitable. but they will also not be able to know whether there is any error, effectively, in the approach the inquiry adopt when making those findings.
If we assume that there's an error made in closed of that nature,
Yes.
how would it be rectified?
Well, the way it operates, because I have some experience of this from things like the Special Immigration Appeals Commission, is that the way it operates is that the special advocates get approval to issue a communication, which they're entitled to do, providing it gets approved, saying there are closed grounds. In that case, it would be of appeal, but in this case, it would be of judicial review. We can't tell you, it doesn't say this normally, but the implication is we can't tell you what they are. The implication being, if you start those proceedings, we will put in closed grounds. And that's generally the way in which it's been advanced. So it's not unheard of for people to put in a simple appeal notice saying, I'm appealing, I rely on whatever the special advocates will put in, and the special advocates put in closed grounds.
So the judicial review would then be entirely in closed hearings?
Yes, with a special advocate, of course.
So you would then have satellite litigation about which the court participants still knew nothing?
But they would have the assistance of their special advocate.
Well, they would know that there was a challenge. They wouldn't know what the basis of that challenge was, and they wouldn't know what the arguments in favour of the challenge were to be.
Well, it may or may not depend. Some of those, it may be possible. Obviously, sometimes what happens is that submissions are invited on a particular point of law. If there's an interpretation point, it may be possible to say what the interpretation is. But I accept it may be that they have no knowledge at all.
And then in the end of the day, the hearing would be conducted in closed.
Yes.
And the judge would produce a closed opinion.
Potentially, yes. Well, yes.
And you would tell you would then tell the family participants that it turns out there was no error of law and the original findings stand, or you would explain that the court had held there was an error of law and what the inquiry was to reconvene or something.
Well, it would be whatever. It would be the same as an open challenge. It would depend on obviously judicial review is a discretionary remedy. It would depend on all the normal principles. But my lord,
never be able to explain to the court participants what the arguments had been, or what had been upheld and what had been rejected.
Potentially. But it may depend on what the circumstances were, but potentially. But, my lord, that would be the same way round. I put the hypothetical, that can operate the other way around, is as I say, if a state participant knows that believes that there's an error of law in the closed, they can bring those proceedings. And again, the families may be in a position where they believe they've got a finding, it's not being challenged.
Yes, I'm just trying to understand how all that would work out.
Well, my lord, I should say you would hope this would be unlikely. I mean, certainly would believe it would be unlikely. But it's important there as a safeguard. What is much more likely, which is why it's important in one sense, is that the special advocates are in a position to say afterwards, even if findings are not necessarily what families hoped for, we attended, we are perfectly happy that there was nothing unlawful that happened. And that's, in one sense, what you really hope will happen, because that's adding confidence. I emphasise the importance of public confidence in the context of Article 2, and that's what you really, in one sense, hope will happen, is that effectively you've got an independent person whose responsibility is to act in the interests of the families, who is able to come back and say, there's no problem here, this was perfectly fine.
Now, you've got a little bit more to go, I think, Mr. Southey.
I have. I've taken some things out of order, and so that will speed things up. But my lord,
is that a convenient?
That is a convenient point. I'll also give consideration again to Carter and Russia, and I apologise. When we had looked at it a long time ago, and maybe we should have included it. But
Could I just ask you one question for me to think about overnight?
Yeah.
Would you anticipate that special advocates, if appointed, would have to be familiar with all of the open material as well?
Ultimately, that's probably a judgment for them. They might need to be. I'd have to accept that. Certainly, the way in my team we're working is that not everyone is looking at every document, and we've got a sifting process and whatever. I can't see any reason why that sifting material couldn't be shared with the special advocates as in one sense, as a shortcut. I anticipate in practice what would probably happen given that is that if we were sharing our sifting material, the special advocates would make a judgment as to what they needed to look at and what they didn't need to look at.
Yes, I mean, it appeared to me that they'd have to know something about the open material at least.
Yes, and they would. I mean, and obviously it depends on who the special advocate is, but the special advocates in the judicial review will know something about the open material because they will have seen all of that. And I suppose they'll need to know. I think that must be right. They'll need to know something. It won't necessarily be every inch of every paper, and there are ways in which that can be simplified by the open advocates providing guides to material, I would thought.
All right, thank you. Is it convenient to reconvene at 10?
Yes, certainly. Thank you.